My lord, may I have
Yes, sir.
my lord's kind leave to mention, my lord, with regard to item number 83.
83.
83, my lord, this is relating to, my lord, the pendency of a bill for about 2 years insofar as the West Bengal University laws is concerned. But the bill was submitted to the
We will see at the end of the day.
the only thing, my lord, this is, my lord, gradually being downgraded.
No, it won't be down. It is wrong. That submission is wrong. This is as per CIS. It will not be downgraded. Upgraded matters
But if,
from 40 to 46. If you want upgradation, then we will see.
my lord, kindly.
Let us consider. Let's just start the list today. Then we will see how we progress.
For some urgency.
I seek your
Unless it is very urgent, please don't mention.
it is urgent.
My lord, I am mentioning item number 915 in the monthly list of part 1. My lord, this is an urgent matter because illegal construction is going.
You give the letter.
My lord, may I mention the item number 888, my lord?
Yes.
The inclusion.
Now it's a fresh appeal.
My lord, this is taken up.
My lord, I mentioned two matters, my lord. One is contempt, another. But 2018, Honorable Supreme Court remitted the matter to this High Court and other High Court.
You have mentioned that in that letter?
Yeah, and also judgment of the Supreme Court is there. The
Very
High
good.
Court
Please,
should supervise the implementation of the Supreme
You
Court.
please enclose that and hand it over to the ACO. We will see.
My lord, maybe let's say kindly give me
My
leave
lord,
to
leave to
mention
file without
for
certified
inclusion in
copy,
the
my lord.
list, for inclusion in the list as an application section.
Inclusion.
That this is I seek your matter relates to Panchayat election. Now, my lord, I have sought for basically two prayers. The investigation into my lord, abnormal filing, a huge number of filing of nominations, my lord. And my lord,
That can't be interfered.
my lord, I tell you, Lordship, I have given example where my lord, the
You
past.
file it, sir. You please file. Leave to file.
Just a second, my lord.
Leave to file is granted. What else do you want? You want us to take the brief?
No. All that I want to move it tomorrow, my lord, because
You file it. It will come 48 hours. You serve notice. Now, heavens
Let
won't
that-
fall. Process nominations are already over. We'll definitely examine your matter. Please.
But one more thing, that may I?
You please, please don't pressurize the court.
I do not want to.
Then otherwise we'll have to release the matter. You file it, sir. Whoever wants to file a matter, please file it.
Who is residing in abroad,
We have heard you, sir.
My lord,
Thank you.
subject to your lordship's kind sanction, may be permitted this matter, my lord, relating to nomination without scrutinization. All this nomination has been filed, and fraction of second, my lord, 70,000 nomination was filed.
It
My
is
lord,
a
8
public
hours.
interest
Leave
litigation.
may be granted subject to lordship's kind sanction.
No, it's a public interest litigation.
My lord, it is not the dispute between the two parties, my lord, and that's why it's a public interest litigation. Your lordship, any date subject to your lordship,
You file it.
at the earliest.
Why do you
I shall-
require for this?
I shall come back serving notice to my lord.
No, you serve notice.
Hello.
You file it in the registry. Why do you require a leave?
But otherwise, my lord, if
No,
the
no,
date
no.
is not,
The
my lord,
moment you make in the what is it, that application, no? What is that form? Presentation form, you give the date, it will come on that date. Have you observed the list?
my lord, I shall, my lord, subject to
No,
your
it-
lordship. Similar matter, your lordship kindly grant this, my lord, only this matter, my lord.
No, I don't know what is this system.
Only this matter, my lord. Both are
But,
similar matter, my lord. It will come along with that matter, my lord.
And then what about people who want to regularly file without mentioning? Why do we want to discriminate between both of you?
My lord, since the urgency is there, and that's why I'm
So
mentioning.
you
before your
serve
lordship.
notice and come, sir.
I shall, my lord.
There is no urgency at all. You are trying to create an urgency.
Serving notice, I shall come back, my lord. Your lordship kindly
Whenever there was
leave be
urgency,
granted, my lord.
we have heard the matter. We have taken it at 12 noon. We have passed judgment on the same day. This is putting pressure on the court. This is simply putting pressure on the court.
No, my lord.
Please call the list.
My lord, item number 54, my lord, may I give you lordship's kindly.
Lordship's
Mentioning
kind
is over
sanction.
for the day.
I shall come back.
My lord,
I shall come back, my lord, filing this.
54, my lord, this is a proceeding suo moto, my lord.
Lord,
Yes.
Lord, extremely urgent, Lord.
My lord, may I
I-
give you lordship's kind leave,
Lord,
my
I
lord?
tell you,
This
lordship,
is my lord, listed matter, my
Lord,
lord. Kindly
lordship, Lord,
take
on
some.
15.
Listed matter, item number
Lord, your
54. This is a
lordship-
suo moto proceedings.
Lord, on
What I'll be
15
praying.
Whatever you want, you give a letter. let
Well,
us
Lord,
see.
what
on-
I'll be
Lord, on
praying, my lord,
15th,
kindly
my
takes
lord
up in a
directed
day
the
which
state
is not
election commission
non-bill day, my lord.
to deploy, Lord, paramilitary forces within 48 hours. Lord, 48 hours is over, Lord, by Friday night. Lord, till now, nothing has been done. Lord, we have filed a contempt application. We're seeking leave.
You file it.
Lord, your lordship, Lord, my lord, the Honorable the Chief Justice, Lord, kindly, Lord, Lord, make it convenient for your lordship, Lord, to see to Justice Uday Kumar, Lord.
You
because it
file
has
it,
to-
sir. You
Yes,
can't
kindly, Lord.
dictate to us.
No, I'm requesting your lordship, Lord, I cannot.
You file it in the
Lord,
registry.
my lord, so kindly,
File
kindly,
it in the registry. Why? He is not the filing department.
Lord, kindly grant me leave
No,
in
no.
this, Lord, this is very urgent.
You file it, sir. You file it. We
Lord,
then
the
mention it.
department will not accept filing before 48 hours, but I want to move it today or tomorrow, Lord. Your lordship's order or tomorrow, Lord.
Contempt petition can come up after 48 hours.
No, Lord, but without leave, it cannot, Lord, come
And
before
we
48
have
hours.
read in the newspapers, both the state and the election commission have filed appeal to the Honorable
Well,
Supreme Court.
let them take that course, Lord, but they have to comply with your lordship's
But
order as
it
long
is
as
our
it is not stayed.
discretion. It is our discretion to give you
Absolutely, Lord,
short
absolutely,
notice.
absolutely.
Don't put pressure on the
No,
court.
not pressure, Lord, not pressure.
Please don't put pressure.
No pressure at all, Lord.
You
No
please
pressure.
file it in the department, let it be numbered, then you mention.
Lord,
it.
may I file giving tomorrow's date only? Only this much?
No, you serve notice.
I'll serve notice.
Yes, you serve notice.
Giving tomorrow's date, may I file only this?
No,
Only
no, no.
this.
You don't. What is the 48 hours this notice period?
Lord, then, Lord, what will happen is
Let
next
us see
48
what
hours-
happens in the appeal.
Lord, they are not doing anything. In today, they did not mention it as per my instruction.
I don't know. We don't know about.
But as per my instruction, no
We
mention.
are,
in Supreme Court.
we are also in the link, my lord,
Lord,
nothing
yes,
mentioned.
chatted, they
We
are
have
not
filed
caveats.
3 caveat, no copy
no
till
copy, sir.
till time, my lord served.
Lord,
And my contention regarding
yes,
my
yes.
13th order. 13th order, my lord was specifically direct to
Lord,
videograph.
Lord, your
My lord,
lordship-
that has not been done, and that is not the subject matter before the Supreme Court, my lord.
your lordship
No
will-
videograph was done. My lord, kindly give me leave to.
Day after tomorrow, you give the date as day after tomorrow.
Well, the kind leave, my lord, item number.
My lord, this matter, my lord, day after tomorrow, my lord.
May I seek my lord
Without certificate.
kind
Lord,
leave, my
kind
lord, to
leave.
mention a matter, my lord. But this
Item
is a
number. Well, I
No, what is the urgency?
The matter, my lord, day after tomorrow, my lord.
No, that's a
Otherwise, registry will not take.
All right, sir, receive it, sir. That's all. Mentioning is
Item
over, sir.
number
Please call the
407.
receipt.
side, Delhi lead.
Yes, yes.
Cutting circuit bench at Port Blair.
Item number
This-
407, my lord, I have
Sir,
some,
this
my
is
lord.
one,
urgent.
Yes, item
my lord,
number
if I
one.
be permitted to mention, my lord.
What is the
Sir, this
circuit
is-
bench
my lord,
matter?
This is being.
Sir, we have called the list, sir.
But may I hand over the slip, my lord? This is.
Appellate
there's
side,
a
Delhi lead
direction by
circuit
the
bench at
Honorable
Port Blair.
Supreme Court, my lord.
You hand over the slip.
Yes.
না কোনো অ্যালাউ করেনি সাহেব ওভার করে দিয়েছে
Yes. What is that circuit bench matter?
My lord, when I appear, my lord, for the respondent,
Ah.
matter was, my lord, mentioned without notice, stay application still not served. And my lord, we received a letter saying the matter will be kept today as to be mentioned. And all my lord requesting is, my lord, let us, my lord, come back on Thursday, my lord, let them serve us in the meantime.
All right.
This is the for the Port Blair matter. I am appearing for the respondents. my lord. We have not been served with a copy
No,
of
no,
the petition.
who's appearing for the petitioner? Somebody was there.
You are appearing the Port Blair matter.
Not the Port Blair. This is a
Somebody is there in the screen.
Item number 1.
specially fixed Port Blair. This the- Item number 1.
He mentioning.
My lord, I am praying for correction 1 order, my lord. Last.
Tomorrow.
My lord, my lord.
None appears for the petitioner. Let the matter be listed after notice is served on the respondents along with copies of the petition and after filing the affidavit of service. Next.
My lord, this,
Deeply obliged.
my lord, this matter pertains to the Port Blair matter. My lord, so it has to be transferred there. The circuit bench is in session right
Yes,
now.
that can be done. All right. Since the circuit bench is in session in Port Blair, the matter be transferred to the circuit bench. Only in principal bench. No, they say that as per the notification, PILs have to come here.
My lord, there's a assignment order passed, my lord, by this honorable court, my lord, which says that all PILs will go before the presiding judge there, my lord. Even today, my lord, in Port Blair, there are 4 or 5 PILs listed in the before the division
You
bench.
verify from Samrat.
There's an assignment order, my lord.
Sign the order.
He said call the
Yes.
list item number.
Please call.
Circuit bench to
Oh,
I appear for the appellants in this
But this
matter,
is,
my
my
lord.
lord, the matter, my lord. I thought my lord had taken up this
No, no,
matter.
my lord, this is a very serious matter in this sense.
I'll my lord make
Yes.
my submissions. But
My
today, my
lord-
lord, it's supposed to appear as a to be mentioned. That is, my lord, the letter that we received from the advocate on record of the.
My lord, why this is important, my lord, kindly consider. My lord, it's a signaling matter in which their contention is, my lord, that we have to define the honorable judge, my lord, with all humility has passed an order saying that earlier for 69 times we have given them the permission. So on 70th time we have to give it. This is the short point. Point is, my lord, if we give it, the accident is bound to happen. Why? The specification, my lord, kindly take the impugned order once, my lord.
No, this matter was mentioned
Yes.
saying that you have filed a contempt petition.
Yes, and,
Yes, my
and
lord, I have tried.
30,000 cost was imposed on last Friday. After we have mentioned the matter upon notice, my lord, kindly
If
see
my
the order
learned friend
passed.
finish, my lord, I
Yes.
will make my submission.
Yes, my lord, today they are proceeding on contempt with all humility, my lord, in a speed which is not very common. Today, my lord, kindly see the impugned order that was passed on 17th of May, saying that, my lord, within 7 days, I have to give them the permission. Kindly, my lord, straight away come to page, sorry, my lord, the order is.
May I just indicate
19th.
that I have not even been served with a copy of the stay
All
petition?
right, we can direct them to serve you,
Yes.
but in the meantime, don't pursue the contempt.
My
My
lord.
lord, may I, my lord, only say this, my lord.
eh,
Lordship keeps it on Thursday. The contempt matter is returnable on Friday. Let them, my lord, serve us a copy of the papers.
No, no.
Matter has been going on for 4 months before the trial court.
No, no.
There has been repeated, deliberate, my lord, an attempt to, my lord,
But
mislead
why
the
have
court.
you not
A
My lord,
very
I have
serious
served,
issue, my lord.
I am giving the affidavit of service with all petition, my lord, email has been served, delivered, received by
No,
them.
I have,
No, no.
my lord,
No, no,
I have
so-
written to
so-
them
no,
that
no, my
whatever
lord,
they
may I-
have served me,
My lord,
the
may I-
attachment is
no,
not
no,
opening.
no,
I'll show you.
no,
I've
my
written to the
my
advocate.
lord, may I indicate one thing? May I indicate one thing, my lord?
Deplorable
No,
conduct on their part.
My lord, very deplorable conduct on their part, but it's a matter of, my lord, national security and accident. Today, my lord, kindly see the order. 17, they say within 7 days, court.
No, you serve the papers now
Yeah.
today.
Let
Yes.
them, my lord, serve Thursday, my lord, will come.
Sir,
back.
you hear us, sir.
I'm sorry. Sorry, my lord. My lord,
But,
I got carried
all
away.
4 of us, all 3 of us are
My
talking
lord,
at the
sorry,
same
my
time.
lord. I just got carried away. I'm sorry, my lord.
You address the court. You don't address your
I'm sorry.
learned friend to your left.
Kindly see the last contempt order, my lord.
You serve the papers. We'll take it up tomorrow.
My
My
lord.
lord, kindly, my lord, give me Wednesday, my lord. Only, my lord, because
No,
I have
no.
a senior, my lord, leading me in the matter, my lord, humbly, my lord, saying, my lord,
My lord, in the
Wednesday.
mean-
Only,
in
my
the
lord,
in
Wednesday,
the
contempt
meantime,
returnable on Friday.
This is
Wednesday, my lord, I'm saying.
in the meantime, my lord, we have to pay 30,000 costs. But kindly see this last order, which we could not annex. Kindly see, my lord, we pay for affidavit. And my lord, the direction is, I'm giving you the prayer for affidavit,
My
but
lord,
this was passed upon their presence.
30,000 cost only if they fail to file the affidavit by a particular day. Let us, my lord, come back on Wednesday, my lord, we'll satisfy you.
My lord, this is on 16, kindly see.
This is the order impugned in the appeal is an interim order, is it?
No, a final order.
Final order.
From that, they preferred the contempt application. 9th, the matter was taken up.
Oh, this is in the contempt.
This is after we have mentioned the matter upon notice to my lord, without recording.
Matter was mentioned, my lord, 10 minutes before, my lord, the court sat, my lord. I have the mentioning notice with me.
Yes.
They, my lord,
because-
deliberately knew that we couldn't have reached. Well, I have the mentioning
My lord,
notice with me. But
with-
this is not, my lord, the order is passed, my lord, before the vacation.
No, the matter is returnable on 7th July.
we have to pay the cost, my lord, within kindly see.
To be
They
paid
pay
within a
21st.
period of 7 days.
Yes.
7 days from the 16th will be. So you got
21st.
time,
Or I'm
Yes,
humbly saying, my lord,
yeah, I got, but kindly see today.
but this is not impugned before us.
No, but I see the subsequent events. Kindly
So
see.
therefore, we will keep it on Wednesday. You
may I humbly, my lord, say Thursday because I have a
No.
leader in the matter.
My lord,
And
this
they
is
have
no,
not
my lord,
served me.
no, my lord, my lord.
They have not served me.
No, we have served, but tomorrow kindly keep it up. Let me present my case.
served.
If my lord doesn't want, if my lord, today everything has been served, my lord.
Nothing has been served.
That's not, my lord, may I only pray for, kindly keep it to, kindly hear the matter. If my lord feels any further assistance is required, my lord will give it.
Wednesday, my
No,
lord,
but
I'll come back,
Tuesday,
my lord.
no, Tuesday kindly keep
Lordship
it.
keeps it on
My lord, kindly see, they have received. I filed the affidavit, but this is not right, my lord. I will again serve. That's true, but my kindly keep it tomorrow, my lord, because
Not
the,
tomorrow, my lord,
no,
Wednesday, my lord.
because my
My
lord,
lord, kindly keeps it on.
advocate for the appellant shall serve one set of papers on the learned advocate for the respondent. Let the matter be listed in the same position on Wednesday.
My lord, deeply obliged.
serial number 224. And my lord, may I only pray for a supplementary affidavit incorporating this document?
leave to file supplementary affidavit granted. And the copy of the affidavit be served on the learned advocate for the respondent.
Deeply obliged.
Now, what we'll do is, see, this is a continuing matter. We'll take it up in the after.
Only one humble request to your lordship, subject to what sir says, the report of the state be
Yes, my
circulated.
lord, I thought that had been served. It's ready, my lord. I'll give them a copy.
That report.
Yes, my lord.
All the parties.
All the parties. my lord.
We have heard the learned advocates for the parties.
Let it appear next Monday in the debate.
Let a copy of the report filed by the state government be served on the learned advocates appearing for all the parties in the 3 writ petitions. List the matter.
Give copy.
May I first humbly pray for 3rd or 4th of July?
10th July.
10th July. Only in the other matter, Yuvan Singh, which has been assigned to your lordship by the Honorable Single Judge, the Honorable my lord's copy Miller. There's only one writ petition copy. Yuvan Singh and duto copy lage na? Second copy.
10th July.
10th July.
2, 3 and 4.
Sir.
My lord, we filed the reports, the 3 sets. My lord.
Lordship, there is some urgency. I shall be giving the learned advocate general names of certain medicines. Lordship, we were very rudely turned away by the center. So therefore, I will be.
Please
right.
inform.
I will.
Next.
Report.
Real report. There has been a fund which has been transferred, that is 3 crores has been transferred to the COE Kolkata. Have the instructions, lordship,
We'll take it on record. The learned advocate appearing for the central government submitted. A sum of these 3 crores transferred to the Center of Excellence by the central government. In this regard, a report has been filed, copy of which has been handed over to the learned advocate general. The report is taken on record. 10th July. Next.
Serial number 5. A Arakta.
Serial number 5, my lord, I am for the
Yes.
private respondent.
My lord, I am for respondent number 8.
Petitioner.
I'm for the state.
He wants to withdraw the permission, stop operation of the way bridges. On what ground they want?
I don't know, my lord. I have all the license. I am the person who is
Person who
operating
is-
the weight bridge, my lord. I have all the license, my lord. And this weight bridge is completely outside of the Panchayat area. And that vehicle which comes in and goes out, that do not use that Panchayat road. And my lord, what I found, my lord, they have given a mass representation, but none of the person is residing within the same Gram Panchayat.
And what is the sum and substance of their objection?
That objection is, they are saying that overloaded vehicles are moving throughout the Panchayat area, so it damages the road. But this is not a correct contention.
Correct. All trucks are overloaded. 100%. That is why National Highways Authority has installed as you enter the toll plaza, in the entrance itself, the weigh bridge is there. Immediately the weight is recorded. You need not take it to 1 kilometer, thereafter get the total weight and come back, compare it to the unladen weight. Now it is a moving weigh bridge. So if you are trying to avoid the main highway and people are going through the Panchayat road, obviously the Panchayat road will be like a truck which can have a payload of 13 tons. Normal weight they take is 22 to 24 tons. Obviously the
that
road
do
will
not
get
use-
damaged. And what is the representation? Why don't you consider the representation?
At the moment, it is not possible for me to consider. But
You
my
are
lord,
for which?
I am for the Pradhan Gram Panchayat.
You need not consider.
My lord,
Ask the district magistrate to consider. This by this public interest litigation, the petitioners seek for a writ of mandamus to withdraw the permission and stop operation of the way bridges which are being operated by the 11th respondent. several allegations have been made in the writ petition. And the grievance appears to be that heavily loaded, trucks which are overloaded are passing through Panchayat roads and causing a lot of damage to the Panchayat road as well as the trees and other things located in the Panchayat area. In this regard, a representation has been given on 3rd of April 2023 to all the respondents, which has not been considered by the respondents. In the light of the above, without going into the merits of the allegations made in the representation as well as the affidavit filed in supposed writ petition, we direct the third respondent, the district magistrate, Jhargram, to consider the representation after notice to the authorized representative of the petitioner and the 10th respondent. The representation be considered on merits and in accordance with the law, and a speaking order be passed within a period of 3 weeks from the date of receipt of the server copy of this order. I saw this
3 weeks from the date of communication.
31-3. Representation is dated 31-3. The petitioner is directed to enclose copies of the representation along with a copy of the order and submit the same in the office of the district magistrate, Jhargram, for compliance of the above direction. Writ petition disposed of. Next.
Serial number 6. The 6 for the
Yes, 6.
respondent state.
What is the allegation against the 7th and 8th respondent?
Well, the allegation is that the Panchayat Pradhan,
have they served notice?
I don't know, my lord, because I am for the state one.
None appears for the petitioner. List on 3rd July.
Serial number 7.
My lord, I am for the petitioner.
Yes.
My lord, a multi-storied building has been made by the private respondent, your lordship. The land on which it has been constructed originally a Dova land, means my lord, a water body.
The fact is this, my lord, Bali is required to be included as a party here because Howrah Municipal Corporation is not a party actually.
And who's the authority who granted permission?
Authority is Howrah Municipal Corporation, but now Howrah Municipal Corporation and Bali has become separated.
Okay.
And now, my lord, it is under the Bali jurisdiction. So Bali is required to be added as a party. Maybe Howrah Municipal Corporation may be added. Maybe there is a party, but Bali is required to be added.
Bali is also a municipal corporation or a
Bali municipality, my lord.
Bali municipal.
And it is guided under West Bengal Municipal Corporation Act, not Howrah Municipal Corporation.
But cannot the, which is the Howrah Municipal Corporation? Yes. Cannot the second respondent forward it to the Bali Municipal Corporation for appropriate
But
action?
we have no control upon the
No. We will issue a direction saying that the representation be forwarded because originally you had granted permission.
We were.
And therefore, with your comments, you can forward it to the Bali Municipal Corporation, municipality, and they will consider.
If your lordship so directs, we can.
The private respondent.
If your lordship so directs, we can do that.
By this public interest litigation, the petitioner has alleged that the private respondent, namely Srimati Gauri Shah,
the
9th respondent herein, has put up illegal construction in a land alleged to be a water body. Initially, it appears that the area in question fell within the jurisdiction of the Howrah Municipal Corporation, and it is submitted by the learned standing council for the corporation that at present the area falls within the jurisdiction of Bali.
One thing, I'm sorry, I'm interpreting. But Bali should have to be included as a party because they will.
Right, sir, doesn't matter.
Because they will comply with the order. Otherwise, content will not lie.
They will comply. Why content? Bali municipality. Since the Howrah Municipal Corporation had initially the jurisdiction over the land in question, it will be appropriate that the representation is first considered by the Howrah Municipal Corporation, and with their comments, the same should be forwarded to the Bali Municipal Corporation, who shall Bali Municipality, who shall issue notice to the petitioner and the ninth respondent, and thereafter pass a speaking order on merits and in accordance with law within a period of 3 weeks from the date of receipt of the comments from the Howrah Municipal Corporation. The Howrah Municipal Corporation is directed to forward their comments on the representation of the petitioner within 10 days from the date of receipt of the server copy of this order. The petitioner is directed to give advance copies of the representation along with a copy of this order to the chairman of the Bali municipality so as to enable the said municipality to comply with the directions.
And my lord, leave may be granted to add Bali municipality as party respondent.
Not required, because they will give their comments and Bali will hear. Next.
Serial number 8.
In order to give my comments, well, we have to give an inspection, make an inspection. Let maybe liberty be given. We are in their jurisdiction.
It is open to the Howrah Municipal Corporation as well as the Bali municipality to inspect the property in question after notice to the ninth respondent before passing orders. All right. Continue. The learned advocate for the petitioner is granted liberty to implead the Bali municipality as the 10th respondent, and the cost rate will be corrected during the course of the day.
That is
Serial number 8.
Thank you. That is required.
Conduct workload analysis in favor of Group C Railway. Job analysis.
Please, your lordship,
Yes.
my lord, in this matter, item number 8, the petitioner is appearing in person. The concerned advocate, my lord, has not been able to reach court. I am humbly praying your lordships not
Next
to take
week?
up the matter today.
All right.
My lord, we'll make it not this week, ma'am.
Next week.
Very good.
Next Monday, same position.
Grateful, my lord.
Next.
Serial number 9.
I beg to appear on behalf of the petitioner.
I am for the respondent number 10, my lord. I am paying for a short Passover, my lord. Mr.
on behalf of the
Hon'ble
Howrah
is
Jilla
sitting me. He is engaged in courtroom number 15, my lord.
What is this memo dated 16th
My lord,
February?
at page, kindly have
Page
a
number?
see page 35. My lord, a drain, my lord, over that drain without any permission, a construction has been created, my lord, there, unauthorized construction without any permission. I wrote letters, every authority. Then, my lord, page 35, it says, if your lordship kindly have a look.
No, the Pradhan has been directed
Yes.
to.
Now, my lord, at this stage, I am only praying, let a report be filed by the Pradhan.
No, he will dispose of. Who
Yes.
appears for the Pradhan? You will.
I am for the state lordship in this matter.
Yes.
Now, my lord, only thing is, my lord, if a report is called for from the Pradhan, my lord, then, or my lord, the Jilla Parishad, what steps they have taken, my lord, since
They will
long.
first consider the representations. We can't be watching all these things. No? This
My
report
lord, I
has
am
been
for the
filed as a
respondent number
public
10.
interest.
Kindly note that I have a sanctioned building plan. They have alleged that we have no permission for construction.
Now,
Kindly note
who
that.
has given the representation?
My lord, the
Sir, it was
petitioner, my lord,
petitioner.
at page 36, the demand,
Villagers, my lord.
All right.
Some
all
of
the villagers,
This writ petition filed as a public interest writ petition alleging that the private respondent has put up illegal construction. In this regard, the representation given through the advocate of the petitioners has been forwarded by the district engineer, Howrah Jilla Parishad, to the Pradhan, to the, one second, to the ninth respondent. The Pradhan,
ninth,
Dilipur Gram Panchayat. The learned advocate for the 10th respondent submits that they have a valid building plan, and the allegation made by the petitioners is false. In any event, the district engineer having forwarded the representation to the ninth respondent, the ninth respondent is to consider the representation in accordance with law. Accordingly, we dispose of this writ petition with a direction to the ninth respondent to consider the representation after issuing notice to the petitioner and the 10th respondent, and after hearing the parties, and also examining the documents that the 10th respondent may produce, and after conducting an inspection of the premises, a speaking order be passed on merits and in accordance with law. This direction be complied with within a period of 3 weeks from the date of receipt of the copy of the server copy of this order. Next.
Serial number 10.
Serial number 10, it is our application, my lord. My lord, here, the basic and fundamental question is, my lord, that at least that so far the health matters are
And
concerned, my lord, the state should be conscious enough.
Who appears for the third respondent?
I'm appearing for the state respondent.
State. So you will appear 1, 2, and 3. You file a report. They say that the public health center doesn't have any facility.
Annexure P5, that is the categorically means how it will be deteriorated.
And
the state's fundamental duty.
You will appear for 1, 2, 3, 4, 6, 7, 8, and 9. Correct?
Except 5, lordship.
Except 5. And have you served notice on 5?
Yes, all. We have already served the.
We have heard the learned advocate for the petitioner, Mr. So-and-so learned. You are senior government advocate.
Lordship, I am not. I am led by Mr. Somdat Sen, lordship. Additional
additional government pleader.
So I am not appearing, lordship. I led by Mr.
All right, whoever it is, he is additional government pleader. And we have heard
assistant advocate general, lordship.
And the additional government pleader appearing for the respondents 1 to 4 and 6 to 9. Notice has been served on the 5th respondent and affidavit of service has been filed. The petitioner alleges that there are lack of medical facilities in the primary health center at Maitrai, M-A-T-I-A-R-I, as well as
Matiari, Nodia district.
F-A-R-A-D-P-U-R, Nadia district. The appropriate authority of the respondent state shall file a report with regard to status report as regards to the facilities which are available, including photographs. List the matter on 10th July.
And get food.
Next.
Lordship, Mr. Sen is having assistant additional advocate general, lordship.
You please give the slip.
Lordship.
Next.
Serial number 11.
Serial number 11 and 12. We have served it upon the state, but service upon the private respondent is not affected till date.
All right. When we
1 week.
1 week.
11 and 12.
11 and 12 at
Another
the request of the learned advocate for the petitioner, adjourned to next Monday in the same position. And in the meantime, the respondent shall be served and affidavit of service be filed. Next.
Serial number 13.
12 perhaps is not analogous to item number 11. 12.
But private respondents are same, including private respondents.
Let him come back. 13.
Misstated.
13, Your Lordship, I am appearing on behalf of the petitioner. It is being laid by Mr. Dutiman Banerjee, my senior. On his ground, may I just seek for a day's accommodation, Your Lordship?
Wait.
I have served upon the other side,
If you
Your
miss
Lordship.
the chance today, it will go to July.
Lordship, I have
Declaration that the amendment of Rule 16 of the West Bengal Special Marriage Rules is ultra virus.
Your Lordship, I am sitting there. I have the affidavit of service.
Have you served the respondent?
Yes, Your Lordship, I have the affidavit of service.
And who will appear for Union of India? Who will appear for State of West Bengal?
I have served them, Your Lordship.
You have served it on the authority.
Yes, Your
Can you give one copy to the office of the government pleader and the office of the additional solicitor general? The learned advocate for the petitioner
Yes,
is
Your Lordship.
directed to serve one set of copies in the office of the learned government pleader and the office of the learned additional solicitor general within 2 days from date. List the matter next Monday, same position.
Your Lordship, government pleader, learned government pleader has been served. And the other one I will do it.
You
immediately.
inform them at least.
Yes, Your Lordship.
There is a change in panel. As a result, there may be some.
Okay.
Next.
Much obliged, Your Lordship.
Serial number 14.
So far, these 14 and 15 are concerned, Milord. Milord, Mr. Devashish Ghosh and Mr. Nirotpal Chatterjee is appearing. I was told, Milord. So kindly make it 1 week adjournment in the meantime, Milord. Because of this, Lordship knows
Yes,
the
yes,
situation, Milord.
the
That's why,
panel has been recast.
Lordship.
And you are here. Very good. not to allow police deployment for private events of the ruling dispensation. Already they are saying shortage of police force.
Right.
Suppose
Lordship, these. Lordship, that may be the case, Lordship, but I'll satisfy my lord on the next occasion, my lord. The authority here is not constitution. Lordship, we have the materials to. Sir, Lordship, these are all government officials who have been deputed on duties for private functions. Lordship, this was an event called Nobo Johar, which was happening in Bengal. This was with respect to primary elections of a certain
now,
regional
how
party.
do we as a writ court say, don't give security here, don't give security there?
No, Lordship, we are not on whether giving security. Our prayer, my lord, will look, our prayer is you provide security, but the cost which is to be borne by every other citizen, that should be borne by you as
So
well.
normally it is done when the single bench in group 9 matters.
Yes.
It orders for, based on that threat perception.
Yes, my lord.
The concerned person has to
To
remit
bear
them.
the cost. That is, Lordship, that is only our contention. My lord will also to look at the prayer. We have not said that don't provide security. If somebody has a threat perception, of course, security has to be provided. But that has to be on the basis of payment of cost.
Then we'll do one thing. We will ask the secretary to consider your request.
Lordship, since he's praying for an accommodation, my lord,
no.
my senior is also not here.
If his
So
lordship, if his lordship pass any orders, my lord,
No,
considering this.
They will consider. No,
Lordship-
actually, this deployment will not take place at the secretary level or DGP level. Probably at the lower level, they may request that this is a program relatable to, suppose there is a program for legal services, district legal services.
Yes,
And the district judge invites the district magistrate. Then they will say, kindly from your social welfare department, if you can just give us 10 staff members. So it may happen. That program may be partnering with some NGO. The NGO will put up the banners, etc.
Right.
But it's very thin dividing lines. How to?
Lordship, kindly I'll ask them to file a report at least why how the deployment has happened. A report.
The petitioner, by way of this public interest litigation, seeks to flag an issue regarding deployment of police for private events. And it is alleged that such private events are being conducted in the state by a regional party in the state of West Bengal without payment of any fee in this regard. It is submitted by the petitioner that the Police Act 1861 mandates that police force has been established for the care and protection of the general populace of the state. And such police force cannot be used as private security agents, more particularly without payment of any funds. In this regard, a representation had been given by the writ petitioner to the third respondent on 1st May 2023. This court can take judicial notice of the fact that whenever the court directs security to be given to a private individual, considering the threat perception, the cost payable for such deployment of police force has to be borne by the person to whom such
Lordship, may I make
protection is
one
granted.
submission, my lord? I'm sorry to interrupt, Lordship.
Such protection is granted. One second. In this writ petition, the petitioner alleges has made certain allegations against the ruling dispensation, which has not been made as a party in the writ petition. Therefore, we are not constrained to, we are not inclined to go into such allegation, but would only direct the third respondent to consider the representation where the petitioner has highlighted that there has been where the petitioner has alleged there is deployment of police force for private purposes without payment of the applicable fee. The representation given by the petitioner shall be considered by the third respondent on merits and in accordance with law as expeditiously as possible.
Since his lordship has not gone into the merit, all points kept open.
Yes, needless to state that the court has not gone into the merits of the allegation made by the petitioner in the writ petition, nor in the representation, and it is for the third respondent to take a decision on merits and in accordance with law. Next.
Lordship may allow an opportunity of hearing, my lord.
Yes, his lordship.
Yes.
14, 15.
Next.
Serial number 15.
In same mamla.
Same.
Yes. What is this, sir?
It is also, my lord, Mr. Devashish Ghosh and Mr. Chattopadhyay is appearing.
Lordship
Blocking.
takes.
Blocking NH12 at Ithar. Why they are blocking?
Lordship, I'm being led by Mr. Mojumdar, Lordship. If this
Where is
fails,
Mr. Majmundar?
He's on his legs, my
He is
lord.
on his legs before some.
Lordship, over here, Lordship,
Anybody who conducts a procession or a rally should obtain requisite permission.
yes, my lord. That is our point.
So then we dealt with that matter, Hanuman Jayanti.
Yes, my lord.
Where the designated route will be there.
Yes, my lord.
And you can't be going helter-skelter as per the organizer's wish. They will lay down so many people, no vehicles, only by foot, no cycles, no carrying this thing and that thing, hockey sticks.
In this way, this is going on.
Lordship,
that
there
is-
Yes.
Lordship,
Now,
Lordship, this is only with respect to the national highways. Lordship, national highways are a property not of the state, of the Union of India. And for any purposes, Lordship, the National Highways Control of Traffic Act, Section 29 says that you have to obtain specific permission.
From
And if you
the-
do not take specific permission and cause mischief, Lordship, that calls for a criminal action under Section 8B of the National Highways Act
and
1956.
who is the person who is competent to give permission?
Lordship, the authorized person from the National Highways Authority of India. May I just read out the provision, my lord? Lordship, Section 8B of the National Highways Act 1956, it reads, punishment for mischief by injury to national highway. Whoever commits mischief by doing any act which renders or which he knows to be likely to render any national highway referred to in subsection 1 of Section 8A impassable. Lordship, the way in the manner that is being done, it was made impassable. No, there was no traffic movement that could take place. For traveling or conveying property shall be punished with imprisonment of either description for a term which may extend to 5 years. Lordship, it is more than 3 years. So this is a cognizable offense, Lordship. The NHAI.
And this is happening according to you only in NH12.
It happened only in NH12 at Itahar on the 1st of May.
ASG is here. He says that.
Representation has been made by the petition. But it is addressed to the Honorable Minister. It should be the Secretary of.
Secretary, yeah.
At page 27.
We'll do one thing. You make a fresh representation to the first respondent.
Lordship.
Within a week or 10 days, and they will consider. Then probably they'll give guidelines to the state saying that this can't be done, this can't be done.
Yes, my lord. There'll be a guideline.
Lordship,
so
but
that-
an offense has been committed and the union should be taking cognizance of that.
But you should have registered a case.
Lordship, I cannot register a case because the complainant in this case has to be the National Highways Authority of India.
By this public interest petition, the petitioner will state that on 6th May 2023, the ruling dispensation of the state being a regional party in the state of West Bengal conducted a political rally at Faraka in district Murshidabad by blocking NH12. Thereby causing great inconvenience to the general public. In this regard, the petitioner has given a representation to the Honorable Minister of Road Transport and Highways, Government of India, on 8th May 2023, bringing to light the said matter and stating that said matter. The Mr. Mazmundar learned advocate appearing for the petitioner submitted that the act of preventing the general public to have free access of the said highway on the said day is in violation of Section 8 capital B of the National Highways Act 1956. And in case such a violation takes place, the punishment which is imposable under the said provision is imprisonment for a period of 5 years. Further, it is submitted that the blocking of the national highway is in violation of Section 29 within bracket 2 of the National Highways within bracket Land and Traffic Act 2002, since it was done without any authorization and therefore it is illegal. We find that the representation has not been given to the concerned secretary of the Government of India, but has been addressed to the Honorable Minister. For the grievance of the petitioner to be redressed, the representation ought to have been addressed to the first respondent. Therefore, we dispose of this representation, giving liberty to the writ petitioner to submit a representation to the first respondent, enclosing all materials. And if such a representation is made within a period of 3 weeks from date, the first respondent shall consider the same and dispose of the said representation as expeditiously as possible after calling for a report from the concerned authorities of the National Highways Department in the state of West Bengal. Though allegations have been made against the ruling dispensation in the state of West Bengal, they having not been made a party to the writ petition, we have not gone into the allegations made therein, and we have disposed the writ petition by directing the petitioner to give a fresh representation, coupled with the direction to the first respondent to consider the same in accordance with law.
Lordship, they will also consider the criminal angle, Lordship.
They will. That is why we recorded your.
And Lordship,
Next.
these two matters, my Lord, since I am appearing, my Lord, can you regularize my appointment? Otherwise, my Lord.
Okay. Mr. Basu Malik is appearing. His appearance be regularized by the concerned department. Next.
Grateful, my Lord.
Serial number 16.
My lord, in this matter, beg to appear for the petitioner, my lord. My lord, the petitioner before your lordship, my lord, challenged, filed a writ petition before before another honorable division bench of this honorable court, my lord, and in challenging the appointment of 24 vice chancellors of different state universities, my lord. And in that matter also, my lord, it was decided that the UGC regulations 2018 is mandatory for all state-aided universities in West Bengal. Further to that, my lord, it was directed in the said writ petition by their lordships, my lord, that within 6 months from the date of the passing of that order, the state laws should be amended in accordance and that with the UGC regulations. Now, my lord, after the expiry of around 3 months, my lord, from the date of passing of that order, my lord, an ordinance has been promulgated by my lord, and that ordinance, my lord, the West Bengal University Laws Amendment Ordinance 2023 is now under challenge before your lordships, my lord. In this ordinance,
But that period of extension is already over.
period,
I think it was extended for 6 months.
no, my lord, it was for 6 months, my lord. Within 6 months, my lord, is subject to correction by your lordships. The state acts were required. There was state acts, my lord, West Bengal University Laws Amendment Act 2014. That mandated that the search committee, selection committee for the recommending the name of the vice chancellor, that has to be that did not keep within the search committee a nominee of the UGC chairman. So that was under challenge. That was another limb of challenge before the
Earlier matter.
in the earlier matter, my lord. And now, my lord, after the passing of that order, my lord, this ordinance has been promulgated, and by this ordinance, my lord, now the UGC chairman's nominee is there as part of the state committee, search cum selection committee. Now, my lord, in this ordinance, my lord, another mischief has happened, my lord. In this ordinance, my lord, 5 persons have been kept as members. Out of them, my lord, 3 are nominees of the state government. How I say?
Page 11 of your petition.
My lord.
The first is a nominee of the chancellor who will be the chairperson, a nominee of the chief minister, a nominee of the chairman of UGC, a nominee of the state government, a nominee of the chairman of the West Bengal State Council of Higher Education.
My lord, I bow down to your lordship, my lord. That is what I beg to place before lordship, my lord. A chancellor's nominee is a nominee of the chancellor. Now, the UGC chairman's nominee, he is the nominee of the UGC chairman. But now, my lord, one is the nominee of the chief minister, one is the nominee of the state government itself. Now, the chief minister is the head of the executive of the state. So, in a sense,
as per the direction issued by the earlier division bench, the then Honorable Chief Justice, if you see your petition, what was the composition then? In view of the above, writ petition is allowed. Page 8. Provisions of UGC regulation will prevail over conflicting provisions of concerning so-and-so. Appointment of Vice Chancellor. Appointment of those respondents so-and-so appointed, reappointed, whose tenure extended or given users who do not possess minimum of so-and-so without following so, are held to be unsustainable without a. Therefore, they have no right to continue. No, show us the UGC regulation.
My lord, I place before lordships, my lord.
Before my learned friend shows it, I have item number 24, similar challenge, not to the same.
Very good. Take 24 also.
My lord, the 68.
Where is the UGC regulation?
My lord, I come to it, my lord. My lord, page 68, my lord. Page 68 towards the bottom of the page, 7.3, my lord. May I read it, my lord? A person possessing the highest level of competence, integrity, morals, and not on that, my lord, I come back to 2. The selection for the post of Vice Chancellor should be through proper identification by a panel of 3.5 persons, by a search cum selection committee, through a public notification or nomination, or a talent search test, or a combination thereof. The members of such search cum selection committee shall be persons of eminence in the sphere of higher education and shall not be connected in any manner with the university concerned or its colleges. While preparing the panel, the search cum selection committee shall give proper weightage to the academic excellence, exposure to the higher education system in the country and abroad, and adequate experience in academic and administrative governance to be given in writing, along with the panel to be submitted to the visitor or chancellor. One member of the search cum selection committee shall be nominated by the chairman, University Grants Commission, for selection of vice chancellors of state, private, and deemed to be universities. The visitor chancellor, that is also important, my lord, shall appoint vice chancellor out of the panel of
names recommended
by the search cum selection committee. Now, my lord,
in terms of clause 7.32i, it can be between 3 to 5. The search committee can consist of 3 members.
My lord, I beg to place before your lordship, my lord, that is where there is the lacuna of the guidelines. It says, my lord, that in the panel of names should be 3 to 5. But it does not say, my lord, does not really mandate the number of members of the search committee.
That is the discretion given.
That is the discretion given. That also I have challenged. Now, I have several limbs of challenge before your lordship, my lord. I have challenged that lacuna in the UGC guidelines. Now, taking advantage of that defect in the UGC guidelines, what the state government now has done, they have constituted a search committee, my lord, in which 3 persons out of 5, my lord, they are virtually nominees of the state government. One is the nominee of the state government itself, one is the nominee of the chief minister herself, and another is the nominee of the Higher Education Council. And as per statute, my lord, the concerned minister, means the education minister, my lord,
he has to be the chairman of the ex officio chairman of the Higher Secondary Council. Now, my lord, this is absolutely, with all humility, I submit, my lord, strangulation with the remaining autonomy of the university, my lord. This is what is, my lord, in a nutshell, what is challenged before your lordship. Another point I have challenged before your lordship, not really I have challenged it because, but I have begged to bring it to your lordship's kind notice that the UGC regulation, my lord, suffers from serious defects, my lord. It does not draw the number of nominees of the search committee and also does not draw the eligibility criteria of the members of the search committee. Now, taking advantage of that, my lord, this the Higher Secondary Council, taking advantage of that, my lord, the state of West Bengal, my lord, has practically practiced nepotism and bias, my lord, and that is what was not the essence of the judgment passed by this honorable court in the matter of Anupam Bera versus State of West Bengal, Anindo Sundar Das versus State of West Bengal, that has taken into consideration the judgment passed in Gambhir Gadhi versus the State of Gujarat, which is in no unclear terms mandated that there should be no room in the constitution of the search committee. There should be no room for nepotism, no room for arbitrariness, no room for bias.
One small clarification.
My lord.
In the earlier division bench judgment,
My lord.
the principal grievance was that the nominee of the UGC
was not there, my lord.
So the court was not really concerned about whether the panel of 3 to 5
my lord
was sufficient,
my lord,
and how the panel should be loaded.
My lord.
That was not the concern.
My lord.
And the court said UGC nominee should be there.
My lord.
And it is directed issuance of that and has set aside the extension, etc.
My lord.
Something has happened. Now, so far as UGC is concerned, can it say that it is not said in as many words who should be the 3 to 5 members?
My lord.
It is said that one member of the search cum selection committee shall be nominated by the chairman.
I bow down, my lord.
But can the UGC say that who will be the nominee of the chancellor, or whether the chancellor can nominate, whether the chief minister can nominate? Can the UGC pass a regulation to that effect?
My lord, with all humility, my lord, I submit, my lord, that has not been drawn by the UGC regulation. But that also I have.
That will be now. If you see the UGC regulation,
it has not said anything.
No, you see the preamble.
My lord.
This is in exercise of the powers conferred under page 38, I am reading, of so and so, section 26, read with 14 of universal, and in supersession of so and so, guidelines, regulations, together with amendment, the UGC here. So you should be able to trace that power either to section 26 or to section 14. If you are not able to trace the power, then the UGC will have no jurisdiction to say that who shall constitute the 3 to 5 members. It has given that discretion. And
I have also annexed the act also, my lord. My lord, in the I humbly submit, my lord, in the earlier amendment act, my lord, all these persons were not even members.
Page 73.
Yes. ওই জায়গাটা কোথায় ছিল না লিখে রেখেছি আমার নোটটা লিখে বার করেছি গম্ভীর ধানের জাজমেন্টের এটা
Now at page 73
my lord
is the Calcutta University Act. There are only 3 nominees.
No, that was, my lord, that is what I beg to place before lordship. By dint of this West Bengal Laws Amendment Act 2014, my lord, these amendments were made in the constituting acts of the respective universities.
Yes.
And in that, my lord, if your lordship has fallen from your lordship, Calcutta University Act was also amended by virtue of that West Bengal University Laws Amendment Act. And my lord, kindly see, my lord, who are the members of the search committee at that point of time. An academician not below the rank of the vice chancellor of a central or state-aided university, or the director of a national institute of higher learning, to be nominated by the chancellor in consultation with the minister, and such nominee shall be the chairperson of the chancellor. This is the nominee of the chancellor. Next, my lord, an academician not below the rank of a professor of a central or state-aided university or national institute of higher learning, to be nominated by the state government. This is the nominee of the state government. And next comes, my lord, an academician not below the rank of a professor or a central or state-aided university or national institute of higher learning, to be nominated by the Senate. So, my lord, there were three nominees, three members, one of nominee of the Senate, one nominee of the state government, and one nominee of the chancellor. Now, once it has been mandated by the Honorable Division Bench that it has to be in accordance with the UGC regulation, and UGC regulation 2018 categorically says that there has to be a nominee of the UGC chairman. Now this mischief has been done, my lord. Now they have brought one nominee of the UGC chairman, one nominee of the chancellor, and three persons, my lord, who are virtually nominees of the state government, my lord. This is, my lord, absolutely means what I beg to place before lordship, my lord, taking advantage of the lacuna.
Where is the corresponding amendment
My
to
lord.
the Calcutta University Act? At page 128 is amendment of Murshidabad, Gandhi University, Darjeeling, Guruchand, Harichand, Guruchand. Can you just make a let us make a comparison?
My lord, my petition. I have, my lord, kindly bear with me for a minute. I have 127. Na?
No, if you see, come to page 126. 126.
126 is the ordinance, my lord.
Yes.
Now,
whereas it is expedient to amend the certain provisions of the Calcutta University Act 1979, North Bengal, etc. Now, where is the Calcutta University Act?
I place before lordship, my lord. Page number 128, my lord. Section 2 in the Calcutta University Act 1979. My lord, may I place it, my lord?
Yes, yes, yes.
Say in section 2 in the Calcutta University Act 1979, in section 2, chief minister means the chief minister of the government of West Bengal. Then comes in clause university. Next comes section in section 8, for subsection 1, the following subsection shall be substituted. The word chancellor, vice chancellor of the university shall be. These are the qualification. At page 128, my lord, kindly come to C, my lord.
Yes.
This is the amendment that has been made.
So the first CI, it is in consonance with, let us have sideways say 73 and 120.
My lord, I bow down, my lord.
So 2C 1I is equivalent to C1.
My lord, C1.
Okay. Then 2 is not there. An academician by the nomination, C4 will be
C2 was 3 was not there. That has
been included
my
because
lord,
of the government.
my lord.
I'm sorry, because of the court order.
My lord.
And 4, nominee of the state government was also there earlier.
It was there.
Now the inclusion is 2 and 5.
2 and 5. 2 and 5. 2 and 5. And nominee of the Senate has been dropped.
Yes.
That is not my concern also, my lord. Even if there should be, my lord. I bow down, my lord.
Because it is an academician.
My lord, I bow down. I bow down, my lord. I correct myself. I bow down, my lord. But that has also been dropped, my lord. Now, my lord, 3 is to, in a sense, my lord, it comes to 3 is to 2, my lord. Now, my lord, what I will place, whenever your lordship directs me, I will place in details also my submissions. Only I have made certain prayers before lordship. I first beg to bring before lordship that I have challenged this ordinance, my lord. I have challenged and I have also prayed before your lordships that the UGC regulations, UGC University Grants Commission, and for that matter, the Union of India, my lord, let them take a decision and place before your lordship, my lord, that what they think about mandate modifying that particular regulation. If their income, because this UGC regulation, my lord, it being a subordinate legislation that has to be placed before both the houses of the parliament. So Union of India also must take a proactive state apart from the UGC. And in the meantime, my lord, I humbly leave it to your lordships, but in the meantime, my lord, the higher education system will be saved, my lord. In the event your lordship kindly draws a guideline, my lord. If that I humbly leave it to your lordship, my lord.
State government means government of the West Bengal. Councillor Act. আমার petition দেওয়া আছে page 160.
আর ওই যে যেখানে বলছেন না 9B2 9 কত section 9B.
Yes, Advocate General will accept. But why was this clause 3 of the original act, this academician was dropped? Normally,
No, it's there. My lord, your lordship will see, my lord, page 128.
Yes.
Provided, my lord, after that, provided that all such nominees shall be persons of eminence in the sphere of higher education and shall not be connected in any manner with the university concerned or its colleges. That's exactly the language of the UGC regulations, my lord. Kindly have a look.
Page 169.
Yes, my lord.
68 bottom. The members of the search and selection committee shall be persons of eminence in the sphere of higher education and shall not be connected in any manner with the university concerned or its colleges. And this amendment of the UGC regulation was one.
My lord, 2018. My lord, this was a 2018 amendment.
So it is after 2014.
Correct. My lord, your lordship recalls, first was 2010. Then, my lord, there were several amendments, my lord, in 2011, 2013. Then, my lord, 2010, my lord, got superseded by, my lord, 2018. And 2018, my lord, is what made it mandatory, my lord, for, my lord, there to be, my lord, a nominee of, my lord, the chairman of the University Grants Commission, my lord, in the search panel.
But nowhere it says the nominee of the chief minister to be included.
Well, no, not as a bar it, my lord. My lord, 3 to 5. But my lord, all the nominees have to be, my lord, academicians. All the nominees, all 5. Chancellors, my lord, nominee of, my lord, the chairman of the University Grants Commission, all 5 are qualified, my lord, by, my lord, that. That is exactly, my lord, what, my lord, the UGC regulations say.
So therefore, virtually it will be 3 people will be the nominees of the state government.
3. My lord, one is chief minister, one is, my lord, higher education, and, my lord, council, and one is, my lord, the state.
But we don't think, from what I know, in a university act says that the chief minister will have a nomination.
My lord, there are. My lord, I can pull them out. There are, my lord. I can pull out, my lord, the acts of all the states. Your lordships will find. My lord, in fact, there is chief justice also. My lord, where chief justice.
That will be there in the national universities.
No. Apart from that also. I can, my lord, show your lordships, my lord, that it's there. My lord, the idea is, my lord, whoever is nominated at the end of the day must be an academician. In fact, your lordships will find.
No, this appears to be overloading the committee with the state government's presence.
My lord, may I, my lord?
Appears to be.
My lord, may I? My lord, your lordship, my lord, it may be apparent, my lord, to that extent. Now, my lord, I make only one submission in question form, my lord, whether there is a bar to that. Because after all, my lord, the vires, my lord, has been, my lord, challenged. That is, my lord, the issue. Your lordship, my lord, whether, my lord, it.
No, that's why they say The UGC regulation also doesn't prescribe and it gives unfettered power.
My lord.
So
Correct.
therefore they have challenged that
Yes,
also.
so they, my lord, they have challenged UGC. It's not their case that we are not in line with UGC. My lord, UGC will go, therefore we will go.
But my lord, with all respect to my learned senior friend, I beg to submit, my lord, that will be a strangulation of the academic freedom of the university, my lord. So that will be, in a sense, my lord, an infringement of Article 14 and 19, my lord.
2014, the Calcutta University Act said that the member of the Senate, the Senate has to select an eminent academician.
My lord.
But the UGC regulation in 18 said that that academician nominee should have no connection with the university.
My lord.
Because some vested interest may come in.
My lord.
So therefore, technically to say that that appears to be in tune, I mean the impugned ordinance saying that the proviso. The proviso is in accordance with the UGC regulation.
My lord, may I only place before your lordships paragraph 52 onwards of the judgment passed by the Honorable Apex Court in Gambhidhan Gadvi versus State of Gujarat and others.
My copy though.
Gambhidhan Gadvi. My lord, if your lordship kindly comes to paragraph 52, my lord, of that particular judgment, my lord. Before para 52, my lord, your lordship.
Yes.
My lord, if you kindly, my lord, if your lordship kindly appreciates, it says, before parting, we may hope and trust that wiser counsel will now prevail, and the state government shall amend the state legislation accordingly on a par with the UGC regulations, which as such was recommended by the His Excellency, the Honorable Governor of Gujarat, as far as back in the year 2014, and even thereafter, the division bench of the High Court had made observations in SCC Online Gujarat para 35 of its judgment and order dated 5/7/2018 in Gambhidhan Kanubhai Gadvi versus State of Gujarat, in which the High Court observed that it is high time that the state government adopts the UGC regulations and amends the state legislation appropriately, so that no room is left for any manipulation, arbitrariness, nepotism, and favoritism before any fresh appointment as a vice chancellor in the state and the universities thereunder are made. As observed here in above, prescribing the eligibility criteria shall not be left to the sweet will of the search committee. It may lead to arbitrariness, and different search committees, in absence of any statutory guidelines and/or prescription, may prescribe different eligibility criteria. My lord, with all humility, I submit, my lord, if three persons who are nominees of the state government, they are allowed to remain in the state in the search committee, and one is a nominee of the chancellor, one is a nominee of the UGC chairman. Virtually, my lord, the authority of the governor of West Bengal, governor or the honorable governor, I beg to correct myself, the authority of the chancellor, my lord, that will just result in just only a signing authority. The nominee of the chancellor will not have a say, even though it's a chairman.
See, this Gujarat judgment was a writ of quo warranto.
Yes,
And
my lord.
in that, the search committee was given the discretion to decide what will be the qualification.
My lord.
That the court came down heavily and said, no, the state has to amend its regulations or the act in consonance with the UGC. Here they have amended the regulation. But how do you presuppose, or how do you, suspect?
Well, that is
A rule
bound.
to suspect, can it be a ground to issue a writ of declaration?
My lord, that is bound to be, my lord. I humbly bow down, place before your lordship.
Ultimately, it is the chancellor who is going to pick up one candidate.
He will only be a signing authority, nothing else. Because he will have to, he cannot, my lord,
I'm not saying about the nominee of the chancellor. The chancellor shall appoint the vice chancellor out of the panel of names.
Yes, my lord, that is what I beg to place before your lordship. He will have to, His Excellency, he will, the Honorable Chancellor has to select someone, has to appoint someone who is recommended by the search committee.
Let us assume your case as it is. Out of 5 members, you say 3, it is overloaded. All 3 are going to choose X candidate.
My lord.
And there are 2 other members. One is the nominee of the vice chancellor, chancellor. One is the nominee of the UGC chair. Those 2 candidates, each one recommend one.
My lord.
So there will be a pool of 3 candidates.
My lord.
It is up to the chancellor to pick up any one of them. How do you say that there's going to be some, how do you anticipate or how do you suspect that the process will not be fair?
My lord, may I?
Ultimate discretion is with the chancellor.
My lord.
He can still reject all names.
My lord, in that event, my lord, at least some protection be given, my lord. Or for the sake of higher education, my lord, I don't have any other notion, my lord. At least this guideline be given, my lord.
One thing, Ajay,
what some protection.
When the nominee of the state government is there, why do you require a nominee of the chief minister? That appears to be superfluous because there is already a nominee of the state government, a nominee of the chairman of the West Bengal State Council of Higher Education. Obviously, such decision may be taken at the cabinet level, will be with the approval of the Honorable Chief Minister. So therefore, that takes care of the situation. So if that is clause 2 is removed, then you are left with 4, it is balanced.
My lord, 4 subject to correction by your lordship, my lord, because someone has possibly subject to correction by your lordship, my lord. I apologize if I am wrong.
See, nominee of the chancellor should be there. Nominee of the state government should be there. Nominee of the UGC should be there as per the regulation.
My lord.
Regulation doesn't speak about other nominations.
No, my lord.
Except nominee of the chairman of the UGC.
My
That
lord.
alone the UGC regulation says.
My lord, I bow down.
So you go to the chancellor's nominee, the state government's nominee, UGC nominee.
My lord.
In addition to that, there will be a nominee of the chairman of the West Bengal State Council for Higher Education. And all those 4 nominees will be persons of eminence in the fear of.
And my lord, possibly, my lord, subject to correction by your lordship, the number has to be an even number, my lord. Odd number, I apologize, my lord. Odd numbers.
Either it should be 3 or.
My lord, may I very humbly place one humble, most humble proposal.
It will be compact if it is reduced to 3. Chancellor's nominee, state government's nominee, and UGC nominee.
My lord.
Ideal, it will be ideal.
My lord, I bow down.
Very smooth.
I bow down, my lord. With all humility, I bow down.
And we need not go into the challenge to the UGC regulation.
Lord, may I just say only one? I am appealing for Union of India. This is admittedly an ordinance with regard to the concurrent list. That is NT 25 list 3. And NT 25 list 3 is subject to the list 1, NT 63 to 66. Now, on a plain reading of Article 213 of the Constitution, which empowers the governor or the president to act an ordinance, that in respect of a concurrent list, previous sanction of the Honorable President has to be obtained. Well, that is not only the provision of Article 213 it starts, but the proviso. Kindly come once in the list to Article 213.
Constitution.
This is admittedly in the matter of a concurrent list. Now, my lord, 213, Article 213, I'm just reading, I have no extra book, so I'm sorry. The first proviso to Article 213 says, provided that the governor shall not, without instruction from the president, promulgate any such ordinance. And that is also reflected in the Constitution Bench judgment. And the last proviso to Article 213, provided that for purposes of the provisions of the Constitution relating to the effect of an act of the legislature of a state, which is repugnant to an act of parliament or an existing law with respect to a matter enumerated in the concurrent list, an ordinance promulgated under this article in pursuance of instructions from the president shall be deemed to be an act of the legislature.
No, what is the repugnancy between the state?
That is in respect of repugnancy. There, when a law is made by the parliament in respect of.
But there is no, appears to be
It's
no.
not a repugnancy.
It's not.
But the Article 213 provides, in respect of a concurrent list, Honorable President's assent has to be obtained prior to issuance of the ordinance. Well, I have gone through a constitutional bench judgment on this issue. That is not me with me at present. The reference is, my lord, I am just giving 217, volume 3, SCC, page 1. If your lordship kindly allows me to read Article 213.
Yes, please.
This, if any time except when the legislative assembly of a state is in session or where there is a legislative council of a state, except when both houses of the legislature are in session, the governor is satisfied that circumstances exist which render it necessary for him to take immediate action, he may promulgate such ordinance as the circumstances appear to him to require. Then next, provided that the governor shall not, without instruction from the president, promulgate any such ordinance if a bill containing the same provisions would, under this constitution, have required the previous sanction of the president for the introduction thereof into the legislature, or b, he would have deemed it necessary to reserve a bill containing the same provisions for the consideration of the president, or c, an act of the legislature of the state containing the same provisions would, under the constitution, have been invalid unless, having been reserved for the consideration of the president, it had received the assent of the president. Therefore, in respect of a concurrent list matter, with great respect, I submit, my lord, the Honorable President's previous assent has to be obtained before promulgation of an ordinance. And that is also reflected in the concluding part of Article 213, that says that provided that for the purposes of the provisions of the Constitution relating to the effect of an act of the legislature of a state which is repugnant to an act of Parliament or an existing law with respect to a matter enumerated in this concurrent list, an ordinance promulgated under this article in pursuance of the instructions from the President shall be deemed to be an act of the legislature of the state which has been reserved for the consideration of a President and assented by him. Therefore, the intention of the of the Constitution, Lord, is that assent of the Honorable President has to be obtained.
But entry 25 list 3 says, education including technical education, medical education and university, subject to the provisions of entry 63, 64, 65, 66 of list 1, vocational and technical.
Yes.
63 deals with Banaras Hindu, Aligarh Muslim University, not applicable. Institution for scientific or technical education, financed by Government of India, is not applicable.
Yes.
Then union agencies and institution, not applicable.
Yes.
Coordination and determination of standards in institution for higher education, or that is also not applicable. If this 62 to 66 of list 1 will have no application.
66 kindly read, my lord. Coordination and determination of standards in institutions for higher education or research and scientific and technical.
But that doesn't deal with appointments of vice chancellors. So undoubtedly, list entry 25, list 3, it's a concurrent list. Yes. Unless and until you show that there is any law of the center which the State Act is repugnant to the Central Act, then needs to be placed before the Honorable President for approval.
But if your my lords kindly take it up tomorrow, I can produce the constitution-based judgment which mandated that in respect of matters under the concurrent list, prior sanction of the Honorable.
So for which you have to show that there is a conflict or there is a repugnancy. In the absence of a repugnancy, where is the question of to be placed?
Well, that is repugnancy is provided in the other articles of the Constitution. In case of where the central government has made a law and state government is making a law, the repugnancy doctrine will apply. But in respect of matters relating to concurrent list, it is not the independent power of the state under list 2.
In fact, that is why, sir, previously the Calcutta University Act had only 3. The governor's nominee, His Excellency's nominee, the nominee of the state government, and an academician. Which 2018 UGC said, no, you should not have any connection with that. And therefore now you say that it will be a nominee of the chairman of the UGC. So state government nominee can be drafted from anywhere. So instead of overloading the committee by 5 members, if it is 3-member committee, search committee, things will move fast.
My lord, that's a suggestion, my lord, which your lordship is making. I can examine it, my lord,
You can
certainly.
examine, but we will consider the constitutional validity.
Yes, yes, my lord, I have no. My
Now,
lord,
what has happened after the amendment?
My lord, I haven't checked, my lord, fully, my lord.
Nothing till now, my lord.
Appointment hoye ki?
No, nothing. The appointments have been some interim governor. I apologize. Some interim vice chancellors, my lord. They are working in different universities. In fact, almost all universities, there are interim governor, vice chancellors. Now, as regards this ordinance, that has not been given effect to.
My lord, since, my lord, while the previous matter was on, my lord, several vice chancellors resigned. My lord,
Yes.
and my lord, the governor then, my lord, those acts said for filling in the vacancy till another appointment is made. My lord, a power is given, my lord, to the chancellor to depute a person to discharge the functions of a vice chancellor. So that has happened. And my lord, those, my lord, persons who've been, my lord, appointed to discharge the functions of a vice chancellor are continuing. Then, my lord, this ordinance, and my lord, as far as I know, my lord, till now, my lord, there has not been any appointment of vice chancellor following, my lord, the, my lord, ordinance.
I also, my lord, what I gather from what is
No,
my information.
Whether the search committee has been constituted.
My lord, I'll check, my lord. Search committee constituted? No.
No, let us see a prayer in the writ
My
petition.
lord, my lord.
Declare Now, what is prayer A? You please read it once more. It's not very clear.
Prayer, my lord, it is, my lord, that is what I place before your lordship, subject to correction by your lordship, my lord. I not for a moment say that it is not in consonance with the UGC regulations 18. Maybe I have written something extra, but it's not.
But you're
It
essentially.
is absolutely dehodes the provisions of Constitution of India, my lord. I very humbly submit, my lord.
So
It is,
essentially, the challenge is to the amendment ordinance.
my lord.
Amendment ordinance.
And my lord, I have prayed before lordships, my lord, for drawing certain guidelines, my lord, so that the transparency exists, my lord, in the matter of appointment of vice chancellor, because in the various judgments, my lord, only for your lordship's kind recollection, my lord, I place before lordship, my lord, that there has been categorically it has been said that there should be no favoritism, and I beg to place, I don't have.
No, but it is too early to suspect.
My lord, may I only for
Let us see your prayer. The other writ petition item serial number 20, is it?
only for academic, my lord, only for academic reason, for my satisfaction, may I place one judgment
See,
for lordship.
But one thing, this is only a search committee. It will only recommend names. The ultimate decision is with His Excellency, the Governor of the state.
Then, my lord,
He will be the Chancellor to take a decision in the matter.
then, my lord, what will happen, my lord, I very humbly place before your lordship, what will happen once they will, a person will be chosen, his name will be placed before His Excellency. Now His Excellency will again send it back. Again, this process will be continuing, and the vice chancellors who are interim vice chancellors
We
will.
don't know. His Excellency may pick any one of them who, in his opinion,
My lord,
is an excellent academician, and he
Only-
qualifies that clause 7 or 7 point something.
7.3, my lord.
2. of the UGC regulations, he can.
My lord, only I place before lordship one judgment of the Honorable Supreme Court, my lord. I have only one book. I beg to place, it's a very big judgment. I beg to place only one paragraph of the judgment, my lord. It's TMA Pi Foundation versus State of Karnataka. That in that matter, my lord, the status of minority institution, my lord, that was to be tested. That in that paragraph 51, my lord, I read it slowly, my lord. It says a University Education Commission was appointed on 4/11/1948, having Dr. S. Radhakrishnan as its chairman and 9 other renowned educationists as its members. The terms of reference inter alia included matters relating to means and objects of university education and research in India and maintenance of higher standards of teaching and examination in universities and colleges under their control. In the report, what I beg to place before lordships, in the report submitted by this commission in paras 29 and 31, it referred to autonomy in education, which reads as follows. University autonomy, freedom of individual development is the basis of democracy. Exclusive control of education by the state has been an important factor in facilitating the maintenance of totalitarian tyrannies. In such states, institutions of higher learning, controlled and managed by governmental agencies, act like mercenaries, promote the political purposes of the state, make them acceptable to an increasing number of their population, and supply them with the weapons they need. We must resist, in the interests of a democracy, the trend towards the governmental domination of the educational process. Higher education is undoubtedly an obligation of the state, but state aid is not to be confused with state control over academic policies and practices. Intellectual progress demands the maintenance of the spirit of free inquiry. The pursuit and practice of truth, regardless of consequences, has been the ambition of universities. Their prayer is that of the dying goeth more light, or that something written, my lord. The respect in which the only up to that I place.
What is the citation?
Citation, my lord. It's 2002 8 SCC. Page, my lord, kindly bear with me, my lord.
TMA Pi Foundation.
TMA Pi Foundation. It's a 230 pages judgment, my lord. It's page 481, my lord.
481, paragraph number.
Paragraph 51 is the
Whether it's a minority view or majority view.
minority. It's a majority view. It's a majority.
My lord, it's part of Justice Kripal.
Yes, Chief Justice Kripal. Part of.
All right, let them file their affidavit. We'll see.
My lord, in the meantime, my lord, only kindly your lordship's desire will be common for everyone. So kindly let there be some protection to the higher education system.
Till now, they have not done anything.
Let them not do it till further order by your lordships. Only this much.
See, that will be causing.
Because they are the interim governor, interim chancellor, vice chancellors are working. I am not satisfied with the qualification of all the vice chancellors.
What we'll do is probably give them 2 or 3 weeks time and prayer for interim relief. In the meantime, if they are trying to hurry it up, you can mention, we'll list the matter.
Only this much protection be given, my lord, at
No,
least.
no. See, this is a writ of declaration. It is the, the settled principle is a statute is deemed to be valid unless it is struck off.
My lord.
So an interim order cannot be granted, which will have an effect of granting your main relief. If we grant stay, tantamounts to
I bow down.
Keeping the
One line order, my lord, that I be given liberty to mention.
yes, we'll not a 1 line, it will be 5-page order. Don't worry.
Keep your life, my lord. I bow down.
What's the use of hearing you, hearing your friend, hearing AG, hearing ASG, unless we record it? Of course, it is all live stream. So please pass on that judgment.
My lord.
Sir, please take down. These 2 writ petitions have been filed as public interest litigations with virtually identical prayer. In WP P263 of 2023, the appellant, petitioner seeks for declaring the West Bengal Ordinance number 1 of 2023, by which the provisions of the various university acts in the state of West Bengal was amended. With regard to the constitution of the search cum selection committee, search-cum-selection committee, for the purpose of recommending names for appointment as vice chancellors of the various universities universities by the chancellor, the excellency, the governor of West Bengal. The petitioner would contend that by virtue of the impugned ordinance, practically 3 nominees of the state government are there in the 5-member search cum selection committee. And this was not the desire of the decision of the Honorable Supreme Court in the decision in the case of and this was not the not desire. It was not the ratio which was spelled out by the division bench of this court in the case of Anupam Bera versus State of West Bengal and others in WPA 170 of 2022. It is further stated that the UGC regulations 2018 states that the chancellor is the appointing authority in the matter of appointment of vice chancellors, but the impugned ordinance heavily loading the search cum selection committee with the nominees of the different functionaries and/or instrumentalities of the state virtually takes away the powers of the chancellor to appoint an experienced and meritorious academician to administer the university. It is further stated that the authority of the chancellor, the excellency is His Excellency the Governor of West Bengal, is diluted and has been virtually treated as a signing authority after picking any one from the panel recommended by the search committee, majority of whose members are nominees of the different functionaries / instrumentalities of the state government, without any discretion. The petitioner in WPA number 274 of 2023, wherein also an identical prayer has been made challenging the impugned ordinance, would submit that overwhelming majority of nominees of the government of West Bengal in the said search cum selection committee is illegal. It is contrary to the settled principles of law laid down by the Honorable Supreme Court, wherein it has been held that there should be least interference of governments in the matter of appointments of various teaching staff of schools and/or colleges and/or universities in India. The learned advocate appearing for the petitioner has drawn our attention to paragraph 52 of the judgment of the Honorable Supreme Court in the case of Gambhiran K. Gandhi versus State of Gujarat, 2022 5 SEC 179, to buttress her submission that the state government should adopt the UGC regulation and amend the state legislation appropriately so that no room is left for any manipulation, arbitrariness, nepotism, and favoritism. before any fresh appointment as Vice Chancellor of the state and the universities thereunder are made. The learned advocate has also placed reliance on the decision of the Constitution Bench of the Honorable Supreme Court in TMA Pi Foundation versus State of Karnataka 2002 8 SCC 481 and has referred to paragraph 51 of the judgment. '51 and 52 of the judgment, wherein it has been held that the governmental domination of educational process must be must be resisted. And that state aid was not to be confused with state control over academic policies and practices. Thus, it is submitted that if the impugned ordinance is allowed to stand, the a fair decision will not be arrived at. In this regard, the learned advocate has also referred to the UGC regulations of 2018 and in particular regulation 7.3, which deals with vice chancellors. The learned advocate general has accepted notice on behalf of the respondent on behalf of the state government, and the learned additional solicitor general has accepted notice on behalf of the government of India. UGC, anybody is there, sir?
I for the UGC.
And Ms. So-and-so, learned advocate has accepted notice for the respondent's respondent University Grants Commission. The learned additional solicitor general has referred to entry 25 of list 3 as also entry 63 to 66 of list 1 and submitted that there are constitution bench decision which would require the impugned ordinance to be placed before the President of India for approval as the subject falls in the concurrent list. After we have heard the learned advocates for the parties, we are of the view that the writ petition should be entertained and the respondents should be directed to file their affidavits. We have noticed that prior to the impugned ordinance, the respective state universities acts provided for constitution of a search committee, and it had only 3 nominees. One being the nominee of His Excellency the Governor of the state, one nominee of the state government, and an academician not below the rank of a professor of a central university or state-aided university or National Institute of Higher Learning to be nominated by the Senate. By way of illustration, we have referred to the Calcutta University Act 1979. Further, the proviso states that provided the nominees as mentioned in the said provision shall not be persons associated with the concerned university for which the search committee is constituted. Earlier, the petitioner Anupam Behra had filed a public interest litigation before this court in WPA page 80, in WPAP 170 of 2022, which was challenging the validity of West Bengal University laws within bracket Amendment Act 2012 and West Bengal Laws Amendment Act 2014 and prayed for issuance of a writ of quo warranto, questioning the appointment of the respondents 5 to 35 therein as vice chancellors of different universities within the state of West Bengal. By judgment dated 14/3/2023, the writ petitions were allowed. Writ petition was allowed. Where is the ultimate conclusion?
My lord.
Allowed, and it was held that the UGC regulations 2018 will prevail over the conflicting provisions of the concerned state universities relating to appointment of vice chancellors, under which the private respondents therein were appointed as vice chancellors. Further, it was held that the vice chancellors who were appointed or reappointed or whose tenure was extended or given additional charge by the state government, who do not possess minimum education qualification condition or appointed without following due process, was held to be unsustainable and without authority of law, and that they have no right to continue as vice chancellors by virtue of such unsustainable orders. Thus, in terms of the said decision, the State Universities Act, plural, had to be amended to be in tune with UGC regulations 2019. As noted above, regulation 7.3 deals with the appointment of vice chancellors, and clause 2(i) of regulation 7.3 states that one member of the search and selection committee shall be nominated by the chairman UGC for selection of vice chancellors of state, private and deemed to be universities. On perusal of the impugned ordinance, we find that the said requirement as directed by the division bench in the earlier judgment has been complied with, and the nominee of the chairman of the University Grants Commission has been included as a member of the search cum selection committee. The other nominees for which the petitioner cannot have an objection are the nominees of the chancellor, His Excellency the Governor of West Bengal, and the nominee of the state government, which was in tune with the provisions of the unamended provision of the various Universities Act in the state of West Bengal. The objection of the petitioners is that one nominee of the Honorable Chief Minister and one nominee of the chairman of the West Bengal State Council of Higher Education has been made, thereby tilting the ratio, thereby virtually increasing the government nominees to 3 out of 5 members. The question would be whether a nominee of the Honorable Chief Minister and a nominee of the chairman of West Bengal State Council of Higher Education is required to be made, and whether the required to be included, and by virtue of such inclusion, whether it would be ultra vires the provisions of the Constitution of India and would and will it lead to governmental domination of the educational process in the matter of selection of vice chancellors. Therefore, we wish to examine this question, for which, affidavits are required to be filed by the respective respondents. The learned advocate for the petitioner submitted that in the meantime, the impugned ordinance should not be given effect. The learned advocate general, on instruction, has submitted that pursuant to the impugned ordinance, the search cum selection committee has not been constituted for any of the universities in the state of West Bengal. This submission is taken on record. We grant the respondents 3 weeks time from date to file their affidavit in opposition and affidavit in reply within 2 weeks thereafter. In the event there appears to be any move to constitute the search cum selection committee in accordance with the impugned ordinance, we grant liberty to the learned advocates for the petitioners to mention before this court for appropriate interim orders.
Deeply obliged, my lord.
We shall give you a date. Sir, would date 3+2, 31/7.
My lord, if it appears as specially fixed, my lord, if it can be given some precedence.
It will be in the daily list. 31/7. We'll take it up now.
Deeply obliged, my lord. My lord, kindly let the affidavits of service. be kept
Affidavit
with
of
the record.
service kept under.
Deeply obliged, my lord.
Serial number 17.
Madam.
I am appearing on behalf of the respondent number 6.
May it please the lordship, my lord, I am appearing on.
My lord. My lord. I have a specs, my lord, but I really cannot adjust with that. So I didn't.
Something in the lighter.
My lord, if I may use an expression, well spotted.
Deeply obliged, my lord.
Yes. Next. This will be common order in item 16 and 20.
Serial number 17. I am appearing on behalf of the respondent number 6.
Yes. Petitioner.
Petitioner, my lord. My lord, I am appearing on behalf of the petitioner, my lord. My lord, this is a public interest litigation, my lord, initiated by the petitioner, who is a learned advocate and member of the bar, my lord. My lord, the issue under challenge is that a stretch, my lord, of Acharya Jagdish Chandra Bose Road, opposite West Bengal Transport Corporation, which is at Nonapukur, and the stretch goes up to opposite INK Hospital, my lord, Neuroscience Hospital. My lord, the entire road, half from both the sides, it's a 2-lane road, my lord, half from both the sides are being blocked, my lord, and there is a Malik Bazaar, a bazaar, my lord, an illegal bazaar, which sits there for 24/7, my lord, and it is not even being lifted. This objects the entire.
We had the other division bench had an occasion to consider a similar matter where the petitioner was an advocate. He was having his residential chambers there. He was not able to enter his house. The municipality and the police and filed a report that these hawkers are there 24/7, and it is very difficult. It is a busy market area. That is the response. Based on that report, the writ petition was dismissed. We have entertained the appeal. We said how they can throw up their hands and say that all fellows, they actually the shops are there. Those people have encroached into the pavement. The hawkers who got pakka shops are on the road. It is a 40-feet road. Now it is a 12-feet lane. This is common feature. They will come forward to the respond, say, sir, we can't do anything because it is busy market area.
Identical, millet. This has been aggravated to such an extent, millet.
It is appears to be a phenomenon.
Millet, electricity theft. It is being road, my lord, it is being
True, sir. We also
my lord,
sympathize with
I
you.
bow down to your lordships. my lord.
See, suppose there is a fire engine which has to come in, an ambulance which has to come in. Very difficult.
It's impossible, my lord. It's not even difficult, my lord. It is impossible.
An ambulance to reach the F gate is difficult.
my lord.
Ambulance reach to B gate is impossible. Unless you have a helicopter ambulance. And on top of the cars only the helicopter
Sir.
is to land.
My lord, with this building, my lord, this structure, it will be very difficult for the helicopter also to.
Nothing can come inside. You've got 2 ambulances stationed. So I used to ask the medical unit doctor whether the ambulance stationed, I think near the F gate, I think, to the court street, whether it can go out. It is parked there. There's no problem. One is near Sesquicentennial. Suppose something happens here, we can use it, go through the other gate. I mean, other exit. But what about here?
The kind of car parking and that will create a.
That is, we are trying to do something. So what is your response? Do something.
Police, the traffic. Is trying, they are level based. Though that is a Mullik Bazaar is a your lordship knows that is a
no
vendors are there.
No, if you build a
lordship can see the report and page 2 and 3 of the report.
And Mr. Dey is appearing for.
I am appearing for the respondent municipal commission. It is the corporation I am appearing for. Now, another matter is being heard by your lordship. That is also public interest litigation. That matter relates to the Street Vendors Protection and Livelihood and Regulation of the Street Vending Act 2014. No, my lordship kindly, my lord kindly. No, in that matter.
Your state missionary, Mr. Dey, your state missionary has thoroughly failed. They have not implemented the provisions of the act. Committee has, the hawkers has not been constituted. Apartments have not been made. Relocation has not been done. Market complexes have not been constructed.
Now, my lord, one thing I should indicate to your lordship.
Encroaches cannot be rewarded, sir. Encroaches cannot be rewarded.
No, it's not a question of reward, my lord. The act is there. My lord, the 2014 act is there.
By 200 square feet of shop area, whole life he has to struggle with a loan. And you are rewarding a person being a state and a municipality. A fellow who's encroaching, you are rewarding him.
My lord, we are the authority. My lord, we have to act within the 4 corners of the statute. Lordship kindly will appreciate this, my lord. My lord, that 2014 act, my lord, there are certain provisions, section 5 and others, which is being considered by this honorable court, my lord, in another public interest litigation where my lord directed the corporation not to treat that as an adversarial matter. Lordship will kindly consider this, my lord, in one of the orders.
No, correct, sir. Therefore, you should be able to place something to say that I have implemented it. I have constituted a hawking committee. I have regulated.
That committee, that is to be formed by the state government. It is upon the state government.
Therefore, the enactment is redundant so far as state of West Bengal is concerned. And where is better evict them? You better evict them.
I'll beseech your lordship, to keep this matter on
take
on 3rd July.
No. Take all those vendors to your municipal corporation office. You put up a clause there. Please ask your mayor, your chairman, sir, please remove all your cars. In front, let all the hawkers be accounted.
My lord, you kindly consider this, my lord. That matter is being taken up by your lordship on 3rd July. My lord, let this matter be also taken up along with that, my lord.
No, we will not.
Because lordship is considering that matter, my lord, and it's on the same footing, my lord. It's on the same footing. That 2014 act is there. Lordship is kindly considering that also.
No, you are trying to make the writ petition infructuous.
No, not that, my lord. Definitely not that, my lord. We are an authority. We shall never try to make that, my lord. We are an authority, lordship. There is no reason why we try to make that.
No, in this writ petition, they say there is a hospital which happens to be a very center for excellence, and there is a opposite side of the West Bengal Transport Corporation workshop is there.
Schools are there, my lord.
Now, if you have established the hawking committee, you would have enumerated the hawkers. You would have classified the hawkers. There is classification of hawkers is there.
Yes, those are there. But in that event,
interim committee could have been constituted by the state government. It did not constitute. When the matter was pending before Supreme Court, every other state has constituted a hawking committee headed by a retired High Court judge. And they have what do you say, identify the hawkers and what type of products they sell. So suppose they are selling some vegetables, day-to-day needs.
My lord.
But most of these fellows are selling garments. They are selling mobile phones, which a normal person every day when he walks home from the office to the railway station, he's not going to buy a mobile phone every day. Probably some vegetable vendor, 3 hours he is there. He may pick up some vegetables, some spices, something required, some milk, etc. And he will go home. And these fellows are selling trendy garments, probably branded stuff. We don't.
There is an entire shop, Millard. That area is established for a shop. But Millard, there are actually pakka structure shops.
We can do one thing. You do one thing, sir. From tomorrow onwards, you start a drive. First, you sensitize. Issues the same thing. Give them 7 to 10 days to remove all the hangers, etc., which are outside the shops. Number one. Existing shop owners have expanded the shop, come into the road. That is point number one. Second is you identify the hawkers. If suppose he is a hawker doing sale of vegetables, small quantity of fruit, then you take them to one corner, allot them a space of like 5 feet by 5 feet. They can sit down, do the vending, close by 3 hours or 4 hours. This can't be a day and night bazaar. This can't be a day and night bazaar. So first sensitize them, use public address system, tell them that if they don't do it, they'll be evicted, and give pamphlets to them. Wait for 7 days. If they don't do, you use your machinery, regulate them. Then you approach the government or you identify an unobjectionable place, take all these fellows there. And your endeavor should be to ensure that those fellows remain there. They don't come back to the street. If you say, throw up your hands, then we will dissolve your municipality.
No.
I'm unfit to administer the municipal laws.
No, that is not definitely my case. We'll do whatever is there they are required for us to do. That is there. Then very good.
The alleged marketplace, as per their report.
Lordship kindly takes up the prayers one by one.
They're motor parts. Motor parts is not, they are not hawkers, sir. Huge number of vendors exist. As such, maximum number of vendors arrive with their vehicles for fitting or repair. So take them to some, call it, what do you say, motor bazaar. Let the corporation build one motor bazaar. Regularize them as tenants. Get them license fee.
Yes, those things. Now, if your Lordship kindly takes up the prayers one by one made in the writ petition, page 13 onwards.
We will allow the writ petition. Third allowed as prayed for.
My Lord will kindly call for a report. What we can do is, Lordship kindly grants us 3 weeks time so that we'll make an inspection at this space, my Lord, and my Lord will file a report to the Lordship. My Lord kindly consult
on public road by persons who are unauthorizedly running a bazaar called as Malik Bazaar. The photographs clearly show that the bazaar is on the road and no appreciable steps have been taken by the respondents to evict the encroachers nor to regulate the hawkers if they are genuine hawkers dealing with goods which are meant for daily consumption. The report submitted by the officer in charge, Park Street Police Station, Kolkata 1, within bracket undated report, addressed to the learned state advocate, reflects a sorry state of affairs. The report admits that there are encroachers and the market area, the encroachers are dealing in motor parts. That be so, they cannot be construed as hawkers. As the definition of hawkers is meant, has been so defined to mean persons who deal with goods such as vegetable, fruits, flowers, etc., which are meant to be purchased by the general public while on their way to their residence after finishing their work. The present bazaar appears to be dealing in motor parts, and they are actually vendors and cannot be classed as hawkers. And the right terminology is they are rank encroachers and trespassers of government property. The court fails to understand as to why the Kolkata Municipal Corporation as well as the police authorities are unable to regulate or evict the hawkers. We wish to monitor the matter and monitor the matter. The respondent police as well as the Kolkata Municipal the officers of the Kolkata Municipal Corporation are directed to issue notices to all the hawkers in the area, directing them to remove the encroachment, granting them about 10 days time. The same shall also be widely publicized using public address system and issue of pamphlets. If those encroachers do not vacate within the set time limit, the respondent authorities are directed to remove those encroachers. And if, according to the respondents, there is already a hawking zone identified, those persons can be relocated in such hawking zone. From the photographs, we also find that shops which are located in the road have also encroached into the pavement and road margin. Such shopkeepers shall be given 3 days time to remove the encroachments, failing which the authorities shall remove the encroachments departmentally. The Commissioner of Police, Kolkata, is directed to issue appropriate instruction to the concerned police officers, and if required, deploy additional forces to enable the Kolkata Municipal Corporation to comply with the above direction. An action taken report be filed on the next hearing date. List the matter on 17th July.
Much obliged.
Well, only I'm submitting, my lord,
Affidavit
issue
of service be kept on
my lord,
record.
only I'm submitting an issue of identification of hawking zone is a pending consideration before losses court in another matter. Here the Central Act is there. Therefore, temporary protection has been provided under the Act itself. Until the hawking zone is identified and town vending committee is there,
Then we can do one thing, sir. You close both the road, both the ends of the road. Give the entire road for hawkers. Absolute solution.
But that is the issue, my lord, considered by the Supreme Court, and on the basis of that, my lord, Supreme
No,
Court
you have
judgment.
slept over it, sir. You have slept over it. 15 years late, 16 years back, hawking committees were formed by other states. What do you want to say? I've been part of almost 7 judgments of the division bench. And I had the exclusive jurisdiction determination for 6 months sitting single. It's nothing is news to me. And
That's
you
right,
have,
my lord, but
sir, you have not framed a regulation. You have not legislated on the issue. And now you are trying to, and Mr. Dey says combined it there. Why you are to
the
encourage?
rules have come out. Rules have come out, my lord. Now that
Then for admit that you are not able to implement, admit it. Then we will do. We will dissolve the corporation and we'll say the executives will run. The elected office bearers will not be there. Elected members will not run the municipal corporation. They will not run. The executives let them run. Sir, imagine a person pays like 250 or 300 square feet of area. He will be paying 10,000, 12,000 rupees rent. And the landlord will demand 6 months, 10 months, 12 months advance. Apart from that, commercial electricity supply connection, higher rates. And with all this, he is trying to do business. And the state is turns a blind eye. A fellow puts a shop in front of his house, front of his regular shop, blocks his access and does the same trade. And the state comes to say, sir, I will protect him. Not the fellow who has got a municipal license, has got an electricity connection, pays professional tax, he pays property tax or water charges, and he pays rent to the landlord. What is all this? His access is blocked. A Pakka shop owner, his access is blocked. Should he not do something? Festival seasons, there are exemptions. Like Puja festival time or some other festivals, religious festivals, etc. General celebrations, New Year celebrations, temporary. License is given for 7 days, 10 days, 15 days. Matters over. But this has become a norm. And you compare your circle, the guideline is called circle rate. How do you determine the value of the property? Government, it's called circle rate or guideline value?
My lord,
Market value, no.
Market value, my lord, market value.
well, now
It's
the
online in
property
WB registration.
property valuation. Now, my lord, the unit area is the method. My lord, there is the procedure. Has
What
been
is it called? Guideline value or?
the guideline is the guideline is there.
Guideline value. So you see the guideline value of certain areas, which were supposed to be VVVIP areas, is inaccessible. Houses are inaccessible. And somebody wants to sell a property there, the guideline value will be in crores, but he will not have access to the property.
But that is where the act has come out for pending constitution.
But shutters, some are open shops where all of them can squat, put up small tables and do their vending. There is a solution, sir. You did not constitute the hawking committee. 15 years back, if you had constituted, all of them would have been rehabilitated. Poor fellows, where they will go? They have some person may earn 150 rupees, 200 rupees a day. And that also he will have to get the product. He has to pay something. We have to face realities someday, sometime. Thank you.
Yeah, much obliged.
I'm grateful to your lordship.
You directed the police commissioner to give
Yes,
us
yes.
action taken report.
Yes, yes.
So grateful.
All of them.
Serial number 18.
May please, Lordship. This is my affidavit of service.
I am for the state respondents, respondent number 1 to 6.
My lord, in this case, my lord, this
Respondent
PIL
number
is
7.
predominantly, my lord, against the advertisement, my lord, which was published on the 29th of December 2022. My lord, that is at page 16A. Now, if your lordship would 16A, my lord.
16A.
Yes, my lord. If your lordship would kindly take up, my lord, the serial numbers 5 and 6, my lord. My lord, we are, my lord, confining the
lecturer in chemistry.
Lecturer in chemistry, my lord, there is one post.
Yes.
And my lord, at page 17, my lord, the lecturer in computer science and technology, there is one post.
Yes.
Now, my lord, this college, my lord, is a government-sponsored college, my lord. My lord, these posts were created by way of a notification dated 17th of May 2017, my lord. That is at page 22.
16A,
16A or 17?
7.
This was created by way of 17th May 2021, my lord, page 22. As your lordship, my lord, got it?
Yes.
My lord, page 24, if your lordship would kindly turn to, my lord.
Yes.
My lord, the list is given, my lord. That is as per the notification dated 17th of May 2017, my lord. My lord, lordship would kindly take up lecturer in chemistry. There is one post which was created, my lord. Lecturer in computer science and technology. There is one post which was created.
Very good.
Now, my lord, if your lordship would kindly comes to page number 25.
Yes.
My lord, if your lordship would kindly takes up serial numbers 1 and serial number 5. My lord, these posts were filled up by one, my lord, Chayantan Das and one Kajuri Ghosh.
Yes.
Which is the serial numbers 1 and 5. My lord, this, my lord, was again, my lord, reaffirmed on 24th of February 2020. My lord, if your lordship would kindly takes up again serial numbers 1 and 5.
Page number?
My lord, 28. I'm so sorry, my lord.
Yes.
My lord, serial numbers 1 and 5, my lord, these, my lord, the posts, my lord, the names are given, my lord.
Yes.
Now, my lord, my specific case, my lord, before your lordship, my lord, this person, my lord, petitioner, is also a part-time laboratory assistant, my lord, in physics, my lord. Though, my lord, he has got no personal, my lord, interest in
No,
this.
he was also in the merit list.
No, my lord, he has no personal, but this is a public interest litigation, but solely on a very specific aspect, my lord. If these posts have been filled up by, and since there are one post of physics, one post of chemistry, and one post of computer science and technology, and these posts have been occupied, then how could, my lord, an advertisement be given insofar as serial numbers 5 and 6 are concerned? In
probably vacancy has arisen.
No, my lord, but that, my lord, let them, my lord, say that on affidavit, my lord. Let them state on affidavit, my lord, that there is a vacancy.
But according to you,
there is no vacancy.
Those two persons.
Those two persons are still occupied.
Shivatan Das and Kajaria Ghosh.
Yes, ma'am.
They are still functioning.
They are still functioning. This is my specific case before your lordship. So if they are still functioning and they have not been removed from the post,
probably it is an additional post which has been.
My lord, let them state, my lord, because my lord, this has been created as for 17th May 2017, my lord.
But this was in 2022.
Subsequently, my lord, notification advertisement issued in 2022. Now, my lord, where are they deriving their power of creating this additional post? My lord, let them state on affidavit that they have, by way of a notification, because my lord, we have done our research. There is no such notification by which, my lord, a further post has been created. My lord, let them state on, my lord, affidavit that they have created a new post, or, my lord, that there is a vacancy with regard to this particular advertisement that they're giving. You didn't.
No, according to your petition, those people have been appointed on contractual basis.
Yes, my lord. Lordship, kindly see now, my lord, What is the contractual business? Lordship, I'm so grateful, man. Kindly comes to page number 30.
No, we saw from your grounds.
Lordship, kindly see page number 30. That was I was going to say before your Lordship. Page 30.
Page 26 itself, it says the engagement is made purely on part-time basis.
Lordship, now kindly takes up page 30.
10,500 per month.
Yes, yes.
Well, let them say, my lord, there is
No, we will say that
Lordship.
probably those two candidates are fearing that they'll be thrown out.
My lord,
And they didn't want to come to court and asked you to
my
come.
lord, we have, no, my lord, I'm telling your Lordship, my lord, if there is, my lord, any, my lord,
No,
because
we will say that admittedly, the posts have not been filled up by recruiting candidates on a permanent basis.
Lordship.
On a 10,000 rupees, what is his qualification?
Same qualification as that of a contractual basis.
No, this she's a doctorate and she's working for 10,000 rupees. And imagine the fee she would have paid for her PhD, for her thesis.
Now, my lord,
Yes, madam, what is your
Yes,
instruction?
my lord, my instruction is that, my lord, it was affiliated, approval was given. Thereafter, my lord, for the running and getting the approval of fund from the government, my lord, the part-time teachers were taken. Teachers or my lord there. My lord, part-time is, my lord, for 2 hours or 3 hours like that, not the whole time. And my lord, contractual will, my lord, act for the whole time. And my lord, in that regard, there are the separate notification for the contractual employees also by the government. My lord, part-time, my lord, they will have no right, my lord, I am obliged to your lordship. I have also those papers, 25, that they cannot, my lord, page 26.
Class 5.
Yes, my lord, the agreement is, an engagement is made purely part-time basis. And my lord, thereafter, an agreement, my lord, clause 4 and clause 5. And my lord, 7, engagement shall be terminated on unsatisfactory performance and or involvement in any.
They have not been terminated.
I have not disturbed you.
So sorry.
Yes, my lord, there is the impediments I have with the records. Who is the petitioner? His list of absence will surprise your lordship. I have with that chart. In a month, 14 days. In a month, 15 days. In a month, 8 days. This is his absence list. And so he is in fear that after employment of the contractual or regular.
But he is not the petitioner.
Yes, Obijit, there is the petitioner.
But I have not come for myself.
Yes.
I have not at all come for, I'm only confining myself to 2 posts.
In guise, my lord, his personal interest is involved. And that is the, my lord, failure for public interest litigation.
No, this petitioner is working as
My lord, he is, my lord, the part-time laboratory assistant in physics. So nowhere connect, but this lecturer, my lord, chemistry, my lord, lecturer in computer.
And my lord, these are the, my lord,
because
papers.
of this litigation, he can't even now apply for this contractual. They'll finish him off.
My lord, I'm telling
and my lord, these are the papers I have come up with all.
My lord, let them, my very simple case, my lord, let them.
Very clear, sir. Part-time, no fetters.
Yes.
10,000 rupees you come, teach for 1 hour, 2 hours.
And 15 classes per week.
Whatever it is. You come late also, what they'll do, they have no control because you can't seek for regularization.
Yes.
Now they are making purely contractual. Contractual will be like, they should be like regular stuff, but they'll be paid pittance. You won't pay as
Less than, my lord, less than.
That is why this modest.
Yes.
You want to violate UGC guidelines.
Yes, yes.
That is why you are putting contraction.
That is what the college and our fund also. Well, that is, my lord, our.
Unfortunately, fellows with PhD are coming for 15,000 rupees.
Well, that is, my lord, contractual appointment. It is the decision of the, my lord.
By this public interest litigation, the petitioner seeks to challenge a advertisement issued by a government-sponsored polytechnic college dated 29/12/2022, insofar as it relates to 2 posts, namely lecturer within bracket chemistry and lecturer within bracket computer science. According to the petitioner, both the posts are manned by 2 individuals and there is no vacancy, and the present and the impute notification is illegal.
Whether they have authorized.
As it is pointed out by the learned advocate appearing for the respondent state, that the petitioner is not a public interest litigant, but it is a private interest litigation in the sense that he seeks to support some of his colleagues. Since the petitioner himself is working on part-time basis as a lab assistant within bracket physics.
Or post.
We have gone through the proceedings of the Department of Technical Education dated 19th February 2020, from which we find Sri Avijit De, AVIJIT. The petitioner herein is working as lab assistant within bracket physics on part-time basis. Thus, there is a tinge of private interest involved in the writ petition, which would have been enough for us to dismiss the writ petition. Nevertheless, since we heard the learned advocates for the parties, we find as to, we propose to consider as to the correctness of the claim made by the writ petitioner. The earlier recruitment, which was made for 2 of the sanctioned posts, namely lecturer in chemistry and lecturer in computer science and technology, along with other posts, was purely on part-time basis on a consolidated remuneration. The said appointment on part-time basis was with a specific condition that the candidate cannot claim any right to regular appointment / absorption in regular post of government service. And their engagement shall be terminated on unsatisfactory performance and / or involvement in any unlawful activity with 1 month notice upon the incumbent. The learned advocate for the respondent could submit that the writ petitioner is a chronic absentee. However, we need not go into the said issue because the impugned notification has called for application for filling up the post on purely contractual basis or contractual basis or till filling up the post on full-time regular basis. Thus, we find that there is that the respondents have not committed any illegality in issuing the impugned notice. Therefore, there are no grounds made out by the petitioner to interfere with the impugned notification. Accordingly, the question fails, dismissed. Sorry. Next.
Serial number 19.
My lord, I'm praying for not today. I'm praying for not.
Not today means July only.
Lord, I'm for the private respondents. My lord.
So I'm for
Well,
the
actually, I'm late by
Honorable
Mr.
Municipality, Lord.
Illegal construction. Why are you putting up illegal construction? That appears to be their submission.
In the garb of, again, my lord, public interest litigation, my lord, they are espousing their private interest, my lord. He is my contiguous neighbor. He is also on the same land.
So you will inspect, they will inspect, both of you, demolish if both of you are put up illegal.
If it is so, my lord, let you sort of first.
And you have sent the lawyer's notice on 26th of April.
Yes.
When did the construction start?
Now, my lord,
reasonable time.
I have the, my lord,
When did you start construction?
I have the mutation in my favor. I have the conversion in my favor. I have all the prerequisites from the municipal commission. My lord, kindly ask them what they have in respect of their construction.
You have got all the documents, all approvals, sanctions. But the only issue is the construction in accordance with the approval and sanctions. That's all.
Yes, no, my lord, another thing. And let them come back, my lord, with the, my lord, they are the municipality.
My lord, another thing.
Whether I have the, my lord, this is the sanction plan, my lord.
Just a minute, my lord. You just send a legal notice, 10 days, you rush to this court.
Well, that I beg pardon, my lord, but the fact is that, my lord, this particular land is already.
This is the sanction.
This particular land has already been acquisition by the government for a particular public.
No, we will only say that this writ petition is premature because you have not given appropriate time. You are appearing for?
I'm for the Rajput Municipality, Lord.
Municipality. So municipality has to consider your representation. He says he's got all papers. He will see your construction also, then take a decision.
But my lord, this particular land is vested.
He will consider everything.
Yes, my lord. Then it will look. Let the municipality consider that whether the land is vested or
way
not.
of this public interest litigation
Consider.
alleges that the 12th respondent is putting up illegal construction in a property which is alleged to be vested with
My
the
lord,
government.
1 minute, if your lordship kindly have a look to this annex chair because they have already responded to my RTI.
Alleged to be vested with the government.
Yes.
we find that the representation given by the petitioner was through his lawyer by notice dated 26/4/2023. And sent by speed post on the very same day. However, without even giving a reasonable time to the respondent municipality, namely the 9th respondent, the petitioner has rushed to his court. The learned advocate for the 12th respondent would submit that the construction put up by the 12th respondent is strictly in accordance with law, and they have got all necessary approvals and sanctions. There is further allegation that the petitioner has also violated the building rules and put up unauthorized construction. In any event, it is for the 9th respondent to look into the matter. And as we find, the petitioner has rushed to this court without even giving a reasonable time to the municipality to consider the representation. The prayer sought for in the writ petition is premature. However, it goes without saying that the 9th respondent should consider as to whether the 12th respondent or the petitioner have put up any unauthorized or illegal construction or construction in violation of the sanction plan, or whether there has been any vesting of the land with the government, etc. Yes. All issues be looked into by the 9th respondent after notice to the petitioner and the 12th respondent. This direction be complied with within a period of 6 weeks from the date of receipt of the server copy of this order. Disposed of. Next.
I did not get the opportunity to controvert the allegation made in
The writ petition has been disposed of without calling for affidavits for the simple reason that we have not gone into any of the allegations made by the petitioner in the representation or in the writ petition against the 12th respondent. Affidavit of service kept on record. Next.
Lordship, kindly the record lordship, the vesting, the municipality is not the custodian of the vesting.
No,
Lordship,
you can
whatever
see.
records available with the municipality will consider that. Kindly, Lordship, kindly.
Suppose
Lordship.
in the car parking area tomorrow I come and give an application for construction with the Kolkata Municipal Corporation. Will you not examine the title?
I have the mutation, I have the conversion.
So
That
you
I'll
call
show.
for, you call
That
for.
I'll show.
That is an allegation.
Lordship.
So you should call for. Next.
Serial number
Take care.
20.
Lordship, I beg to appear on behalf of the petition.
Yes, sir.
In this matter, the petitioner is a refugee in the plots of land. There are the 45 families are residing over the 50 years more. And there, my lord, the voter card and Aadhaar card has been published. Now, by the approval of the BDO, they have formed a committee. That is, my lord, the Udbastu committee. They made a application before the the authority concerned, that is, SDO, for the granting of patta. And in the meantime, there is the Pradhan and as well as the some of the private respondents, 10 and 11, in connivance, they have been dumping the garbages. They have been preparing the VAT. And now the petitioner makes a lodge a complaint to before the SDO to protect his rights.
What happened to that complaint?
My lord, that complaint is, my lord, has not been decided. In the meantime, before the pending of the
No. This must be. No, what is that project called? Construction of community level, rural.
Solid waste management project.
That has to be constructed, sir, as per Supreme Court decision. In fact, sitting in the division bench, I passed an order not to construct. My order was reversed.
Higher authority.
They reversed. Because now what they say is, you decentralize the garbage. First segregation. Now they have started segregation. Compostable, non-compostable, hazardous. Segregation at home. It starts from your home, office, establishment, industrial establishment. On segregation, it will not be taken to that dump yard near Kalighat. It won't be taken there. I'm sorry, Dakshineshwar. It will be in a solid waste management system. In the locality, they will identify. There the processing will do. Then the processed waste will be shifted. You ask your council who appears for the pollution control board. What is his name? I forget. What is his name? Pollution control board. Huh? Pollution control. In fact, in one matter, he handed over one booklet. What they are doing? Because in state of West Bengal, it is only 9% of the solid municipal waste is being processed. So this mini plants or mini areas will be located in every residential area. Probably part of a park they will take. In that case, which I am saying, where I pass order sitting in my parent high court, they took a part of the park. So we said, no, it should not be. Children's park.
Children's park.
And it was a huge housing layout consisting of more than like 3,000 plots. Then they gave statistics. How much of waste will be generated? But there should be sufficient safeguards. If you start dumping and don't process, then it will become a dump yard. And what you can't remove, but you can end.
There is an apprehension to remove from the said premises.
That is difficult because it is pursuant to Supreme Court direction. This each Gram Panchayat, municipality, corporation, they have to establish this solid waste management system, SWM. Of course, corporation area, you got these compactors which will come take in the truck. But municipal area, it's only by 3-wheeler or something they will do. The petitioner is aggrieved by construction of a solid waste management project at a community level in the Gram Panchayat. The apprehension of the petitioner is that it will be turned into a dumping ground. The apprehension of the petitioner cannot be totally brushed aside. Because if the solid waste management system is not properly implemented, then it will become a garbage dump yard. However, since the garbage has to be segregated at the place of where it is generated, be it a house or an office, etc. And the segregator garbage has to be taken to the solid waste management area to be processed and thereafter to be disposed of in accordance with the guidelines. Therefore, we dispose of this writ petition by directing the fifth respondent to ensure that the ninth respondent who has been entrusted with the contract of putting up the project scrupulously implements the project and ensures that the garbage is not dumped and left unattended. In the event the ninth respondent does not do so, the petitioner is granted liberty to report the same to the third respondent, to the second respondent, namely the block development officer, who shall immediately issue appropriate instruction to the concerned panchayat, to the fifth respondent and the ninth respondent to remedy the breach. With the above observation, writ petition disposed.
The affidavit of service in kept on.
Affidavit of service kept
and
on.
along with some supplementary affidavit, I have alleged some complaint regarding this.
You give copy.
The copy.
Don't you think the allegations made in the writ petition, since no affidavit has been
No, that we have said. We'll stop with this.
One leaf is granted, there is some mistake in the top. There is a district Nodia. It has been written as district South 24 Borganas.
It is submitted by the learned advocate for the petitioner that in the cause title of the writ petition, instead of district Nodia, it has been mentioned as South 24 Pargana. The advocate, learned advocate for the petitioner is permitted to correct the costing. Yes, sir.
Well, I have one personal request, which is very personal. Item 22. That's
Next one.
Well, 21, 22. Rathayatra festival, well, in my constituency at Shirampur, this is the second largest Rathayatra festival in country. Well, I have to live by it. Kindly just well, personal ground, I am accordingly.
That is item 21.
22, my lord. 22, my lord, I am appearing for the petition. Item 1, check.
And when do you want it, sir?
22.
On what date?
Tomorrow at 10, tomorrow at number 1, so that I can leave my 12.
Tomorrow it will come.
Tomorrow.
Today 2:15 is original side. Huh? Tomorrow your matter will come as item 2. See, we have come up till 20. Yeah? Dipesh, you have come up till 20.
No, public.
Your item will be at number 2 tomorrow.
If it is remains.
But on top, suppose some to be mentioned.
Lord, I am afraid of this, Lord. That's the reason I am mentioning. I know this too, but maybe some matters.
To be mentioned means some correction in the order.
Oh, okay, my lord. I want to leave by 12. That's the only request, my lord. Otherwise, I will be very. Yes, it's a very personal request.
Yes. Okay. So your item will be 3 tomorrow. 3.
No problem. No problem. Sometimes personal grounds.
Yes. So we can.
Religious.
Lordship, may I pray, Lordship?
No mentioning now.
Lordship, I am not, Lordship, only my prayer is, Lordship, with respect to item number 38, Lordship. This matter is relating to election matter. I am praying for in this matter, the election commission violated 46 subsection 2. Kali take up the matter tomorrow, Lord. Kali
tomorrow, yes.
They called us. তুমি আমি
দাদা সেকেন্ড হাফ অরিজিনাল সাইড তো
কালকে চলে আসবে
সাত নম্বর আইটেমটা যেটা লিভ নিতে বলেছিল না, লিভের জন্য লিভ নিতে বলেছিল, ওইটা একটু একটা রেসপন্ডেন্ট অ্যাড হবে, বালি মিউনিসিপ্যালিটি
এখানে প্রেজেন্টেশন করেছে আমার করতে
ইন কোর্স অফ দ্য ডে বলেছে না, ইন দ্য কোর্স অফ দ্য ডে বলা আছে তো, কালকে করলে তো এটা কালকে তার লিঙ্ক থাকবে সই করে আজকের জন্য। এয়ারপোর্ট 3 বল্লভ ঘোষ ওই কর্নারে 17 নম্বর বাড়ির ওইখানটা, তাই তো 11 নম্বর কোর্টের ওপরে যে জায়গাটা, ঠিক আছে।
Hello. এই আমরা একই থাকি তোমাকে যাবো। দাদা খাবে না। হ্যাঁ, কোথায় খাবো? আমি খাবো না। গেছিল। হ্যালো।
Afternoon, I'll keep, I'll be starting to give you feedback one after another. I'm in the process where I am, if I get any compatibility or any minimum, so then I try.
আমি ভাবি দুখানা শশা তার জন্য এত বড় ব্যাগ
চা আছে, জল আছে। টাকাতে পড়ে দেখো ওইটার সঙ্গে যোগাযোগ করি আর আমি করছে তো আমি এটা কলকাতায় চলে আসবো।
কোথায় গেলে এলে না ঘরে আছি
Now then,
না না সকাল ছেড়ে দেবে না
এমনি দেখতে পারো না দিলে না দিলে
তারপর আমি আচ্ছা যাই হোক দিয়ে তারপরে তো তাহলে আমি তোর বাড়ি গিয়ে তোকে তো নিয়ে তো আসবো না সেটাও নিয়ে আসবো।
এই যে অঞ্চল সামনের দিকে তোমার বন্ধু বড় লেকচার মানেন যে নাকি সিপিএম কমরেড এর বাপ্পা এদিকে ঘুরে বেড়াচ্ছে তারা বিদেশে তারা ঘুরে বেড়াচ্ছে শিখেছিলি এই গরিবের বাপ্পা ও নাকি গরিবের বাপ্পা কমরেড নাকি হ্যাঁ ওই কমরেড উপোস ছাড়িয়ে দাও দাদা আমি থাকতে পারলাম না তখন অন্য ঘরে ধরেছি বললো কি হলো ইমিডিয়েট ডাইরেকশন কিন্তু এজি এজি কি বলছে কি এটাকে সমর্থন করছেন না অপোজ করছেন হ্যাঁ এখনো সার্চ আগের জাজমেন্ট অনুযায়ী সার্চ কমিটি এখন কনস্টিটিউট হয়নি না তাহলে যে এডুকেশন মিনিস্টার অফ দ্য স্টেট এডুকেশন মিনিস্টার একটা যে একটা প্রেস কনফারেন্স করে বললো না কদিন আগে যে যে কোনো যাদের যাতে গভর্নর বা একটা ইন্টারিম রিলিফের জন্য টেম্পোরারি অ্যাপয়েন্টমেন্ট দিচ্ছে ওগুলো আমরা চ্যালেঞ্জ করছি ওরা কি এর মধ্যে আছে নাকি ওইটাতে হয় স্টেটের এজি স্ট্যান্ড আলাদা না হয়ে যায় তাহলে মুশকিলে পড়ে যাবে এটা আজকে আজকেরটা হ্যাঁ অ্যাপয়েন্টমেন্ট অফ ভিসি যেটা বলছে ইন্টারিম ম্যানেজমেন্ট যেটা হয়েছে সেটা চ্যালেঞ্জ করেছে কি তাহলে তো ওটা তো স্টেটই তাহলে করেছে কন্ট্রাক্টর না তাহলে তাহলে শোনো তাহলে আমি এজির সঙ্গে কথা বলি বা কাকে দিয়ে করিয়েছে অদ্ভুত একটা ওখানে তো গভর্নর না গভর্নরের অর্ডার তো হয়েছে এটি কি বলতে জানতে হবে সেটা আমার এডুকেশন মিনিস্টার নাকি পেপারে পড়লাম প্রেস কনফারেন্স করে জানিয়েছেন দেখছিলাম আচ্ছা ঠিক আছে।
তোমার কথা বলার পরে
আমার ভালো মামলা বড় সেন্সিটিভ অনেক ল পয়েন্টস আছে। আমার জুনিয়রকে দিয়ে বললাম যে তুই মেনশন করে সোমনাথ করে মেনশন করে লিস্টে কর। এই সব যদি এখন এই বয়সে করতে হয় আমার তাহলে এবার গেল সোমনাথ গেল মেনশন করে গেল পয়েন্ট অফ ল এখন আমি সব শুনবো না। আর্বিট্রেশন ম্যাটার সেকশন 11 ওটা ওরই তো ওর বলছে কমপ্লিকেটেড কোশ্চেন অফ ল এ পরে শুনবো এখন পরের মাসে এখন এসব এখন হবে না। তারপরে তোমার কথা হলো বলেছি পয়েন্ট কি আছে পরে আবার আমাকে যেতে হলো মেনশন করলাম সাথে একটা নোটিশ দেওয়ার ও ইয়েস ভেরি কমপ্লিকেটেড ভেরি আইল টেক আপ ইউর ম্যাটার
আমি ভুললাম 27
বাইশে না আমি এখন এই মাত্র করবো না এই যেটা কারণ এই মাত্র বললাম আমি এখন আমাদের পৌঁছয়নি যেমন যে যেমন করছে করুক পরে আমাদের আমরা যে বিষয় পরে দেখেন আমার হচ্ছে ম্যাকাও
এখানে আসবে না
এখানে তো ম্যাকাউটের ইনস্ট্রাকশন ছিল এটা ইন্টারভেন করা
কোন মামলাটাতে বলছো বাইশে পার্টি আছে
ম্যাকাউট পার্টি আছে এই মাত্র বললো অ্যাপিয়ার করতে হবে না আমাদের তো ষোলো দেন আর 70 টাকা তাহলে এটা কোনটা 22টা কে করেছে
22টা করেছে
যেটা বার্তা বছর প্রেস কনফারেন্স স্টেটমেন্ট এন্ট্রি মেজার্স হিসেবে যেটা দিয়েছে সেটা আমরা মানছি না এটা তো
রাজ্যপাল করেছে এটা হচ্ছে মেন নাম্বার
কনসালটেশন হতে পারে
হতে পারে না রাজ্যপাল যেমন বলছেন রাজ্যপাল যে 13টা করেছে তার মধ্যে 7টা আর নট এলিজিবিলিটি অ্যাপ্লাই করতে প্রস্তুত ভাইস চ্যান্সেলর কেউ কলেজের অধ্যাপক
এখন চ্যালেঞ্জ করছে তার
কেউ কলেজের অধ্যাপক কেউ 5 বছর
আমি খুঁজছিলাম যে ওটা কোন মামলা এদের বলছি
স্টেটের হয়ে
এই রাজ্যপালের খুব বাজে কাজ করছে কেন
তাহলে তো অ্যাডভোকেট জেনারেল তো আপনি করা উচিত
অ্যাডভোকেট করছে
আপনি কারণে হচ্ছে
করো তাহলে আমাকে
না না আমি তাহলে আপনি দাঁড়ান আমার ওইটা ইনস্ট্রাকশন আছে টাকা ওটার করতে যখন আছে আমি কেন আপনি
না না সময় 16ই ছিল না 22-এ ছিল
16ই ছিল 22-এর কথা এক্ষুনি বললাম আমি আরেকবার বলুন রঞ্জন এইটা কোথায় পাঠিয়েছি
এইটা
বললে আমি বললাম মামলা জানো হ্যাঁ তুই আমাকে পঞ্চায়েতটা বলবি মামলা হয়েছে তুই আমাকে মামলা পাঠিয়ে দিবি এই আমার ভাই কোথায়
Department of Environment.
দাদা আপনি আছেন তো
না না
আপনি বাদ হয়ে গেছেন
ওর সঙ্গে ছুটিতে আমার বিরাট ঝগড়া আবার
আবার আমাকে দলকে বার করতে হবে না কারণ হয়ে গেছে কিছু আমাদের একটা কথা ছিল
আর তুই পেনশন করতে যদি এখন আমাকে যেতে হয় আবার আমি
নতুন যে এসছে তাকে নোট দিতে হবে আবার
এই জায়গায় আবার জায়গায় ফিল আপ ঠিক আছে
ঝামেলা হয়ে গেল আমাদের হ্যাঁ আমাদেরই তো ঝামেলা
এতদিন আমি দেখো অ্যাড্রেসটা এটা দিয়ে দিন
ও এটা
কোন মানে কি আর কিছু লিখতে হবে না অনেক জায়গায় দুটো আছে
আছে না লাইনে চলে গেছে এই সারা মানুষের যখন হবে হ্যাঁ সেনার তো ওদিকে
Yes. नाम लेकर Picture of
স্যার অ্যাপিয়ারেন্স বলেছে
মানে হিয়ারিং
হ্যাঁ, হ্যাঁ।
অ্যাপিয়ার করতে বলে প্রত্যেকদিন হিয়ারিং।
সেটাকে ডিসপেন্স উইথ করিয়ে নাও
হ্যাঁ দাদা একটা
আরে ডিসপেন্স উইথ করিয়ে নাও আর কি করবো রেগুলার
এর আগে
দাঁড়িয়ে
কি-
থাকা মুশকিল
হ্যাঁ দাঁড়িয়ে থাকা মুশকিল না।
তো দুটোর পর থেকে কাজ হবে না ও অ্যাডভান্স করে ইয়ে করেছে বুঝলে চিফ জাস্টিস কি করে
কাজকর্ম নেই এইসব করেই বেড়া।
হিসেব করে চলে যাবে
এইটার অর্ডার শিটের আর একটা কপি হবে।
My lord, in compelling circumstances, my lord mentioned this matter, my lord, kindly leave me granted to file this memo of appeal without certified copy, my lord.
My lord, may I be permitted to mention one item in the appellate side of your lordship's daily list? My lord, item number 82. In this matter, your lordship directed.
Tomorrow you can mention.
No, my lord, what happens? Your lordship directed to the inspector in charge of Bakura police station to ensure the presence of some of the persons who are attached with the Alexander institution. So, my lord, as per your lordship's direction,
Yes,
my lord,
yes, I remember.
so, my lord, your lordship kindly dispense with their applications so that, my lord, they are appearing, my lord.
Today they are appearing.
So, yes, my lord, they are. Yeah. Some of them, my lord, as per the police, and this is the report of the police.
And they are the Alexander institution.
Yes, my lord, because as per police report, I don't know, my lord, who are there. It is a police report, police investigation.
No, it
whether
is
the
running.
matter would be taken up tomorrow at the top so that they can.
Tomorrow, second half, the bench, regular bench won't be there. The special bench will be
The
there.
first page, my lord, 82, item number 82, today's list, my lord.
Today we will record their appearance.
Yes, my lord.
But we will not dispense with their appearance on the next date. They have to appear. We will give them a date. We will fix a date then tomorrow.
Yes, yes.
As and when it reaches.
Whether they will come tomorrow or not.
Not required. Not required.
My lord, may I permit to
That appellate side.
Item number 82.
I want to record. So item number
82.
82.
My lord, this is the order of your lordship. My lord, relevant page, my lord, I have. My lord.
But
page 3 of the.
They don't appear to be
Yes, my lord.
trustees.
I think so, my lord. I have already, my lord, contacted with the IO. I think they are not practically. I think, my lord, they are
some employees. By order dated 6/6/2023, direction was issued to the inspector in charge, Bankura Sardar Police Station, to ensure the physical presence of all the office bearers of the Alexander Educational Trust and Welfare Society. The inspector in charge has secured the presence. And today, how many of them are appearing?
4 of them appear. My lord, this is a report, police.
And 4 of them stated to be the trustees of the Alexander Educational Trust are appearing. In order to verify the correctness of the said stand, we direct the 4 persons. That is
সেখানে দাঁড়াও কি নাম তোমার সিদ্ধার্থ পাল আমার তো খুব ভালো সুব্রত কি হালদার সুরজিৎ রায় স্যার কি বলবো
But even as per the report, there are only some employees, peon, etc.
Yes, my lord.
What did he say, sir? We direct the 4 persons to appear before this court as and when the matter is heard. It prima facie appears that the 4 persons are only employees, and are not the trustees of the trust, nor the office bearers of the 10th respondent. Since the matter could not be taken up, all issues will be considered on the next hearing date. The presence of the 4 persons is recorded and they shall continue to appear as and when the matter is taken up before this court on the next hearing date. Let them appear. But I think you speak to the higher official and tell that they are trying to hoodwink the court. How they will come and go. We'll fix a date.
Today, my lord, 6 persons has appeared, my lord.
6,
So, my lord,
4, 6. Let the matter appear on 26/6.
my lord, they are related to Camps College, but they are not related to Alexander.
Alexander.
Because Alexander College is, my lord, probably at Karnataka. But I have already talked with them that you should go there and my lord,
Let
take a
them
brief of
secure.
it.
Let them be here. They can assist the court. Let the
They
matter
will-
appear on 26/6 on top of the list. And the 6 persons who appeared before court today shall be present on the said date. Thank you, sir.
My lord, report may be kept.
The report submitted by the inspector in charge is kept on record.
Well, under compelling circumstances, I have to mention before your lordships, my lord, appellate side, my item number 59. Urgency last Friday, I have mentioned the matter before your lordship.
Tomorrow it will, there are good chances it will reach.
59.
Let us see. Yes.
Because my lord, entire police recruitment, my lord, in the matter, my lord, is
We
involved.
will see. We will see. Definitely. Thank you.
Original say daily list My item lord, may I number permit 1. to mention, my lord, may I permit to mention, my client has to flee away from Canning SD office without filing the nomination of election because of the riots. So my lord, kindly give me a leave to file the writ petitions.
You file it. Where are your papers?
My lord,
You file it in the registry. Automatically it will come. Yes. Item 1. How many days delay? 238.
My lord,
Respondent served.
my lord, it
Returned.
There is no such.
We have heard Mr. Amit Sharma, learned advocate for the petitioner. Fresh notice to the respondent, returnable in by so and so date. Affidavit of service be filed on so.
item number 2, public interest litigation.
All right. So no order is to be, no order passed. Okay.
Item number 3.
Yes.
Lord, public interest litigation,
Yes.
well, complaining of constructions being carried out at government land. But orders have been
earlier order.
Previous order.
Well, the difficulties that others said will never let
No,
me.
I am requesting lordship to see your lordship's order so that that
Correct,
can be
correct. So
implemented.
if I don't give your lordship a basic overview of the matter.
Order is sufficient.
Nah.
Writ petitioner is present in court today.
My lord.
As per the earlier order.
Yes, yes, yes.
They said he is a fictitious.
So that is what I wanted to address your lordship on. My lord, your lordship is aware of that Protection of Whistleblowers Act.
Yes.
Why it was the very object. My lord, I have in the envelope before your lordship, the documents, the original Aadhaar card of the, basically, my lord, we are, the entire allegation is against a person basically who's been carrying out the construction. So, my lord, he has got sufficient reasons to apprehend that if he is identified, unlikely that he'll survive for too long. So he says he has got just sufficient reasons to apprehend that. So, my lord, I have, my lord, subject to.
He can appear before the.
Yes.
Registrar General.
But I have also brought the
Police
original.
protection. Can I give him police
No.
protection to be
Police
appear here?
protection against them.
Military
Lordship
protection,
knows
defense
better.
protection.
No, my lord, I have the original document, the Aadhaar card for your lordship's consideration. Kindly have a look for his. And even if there, despite this, if your lordship is aware, lordship can indicate any date and time where before the Registrar General or any other officer of your lordship where he will appear. My lord, yes. Kindly do not indicate the date and time in. So, my lord, your lordship indicates otherwise. No, we don't want them to know when is he coming. We don't want them to identify my clients. It's as simple as that.
Let it be held in camera. If he is so much apprehensive, let it be held in camera.
So then what will the camera do after that?
This apprehension was not there when Mr. Bose has apprised your lordship that he will be coming before your lordship. This apprehension was not there on that date.
And on that day, Mr. Bose said he will ensure his presence.
Correct. I
But
did.
today, his client is afraid.
Today apprehension comes in.
No, he is afraid of his life.
On that date he was not.
Will Mr. Basu or Mr. Dotto give an undertaking that nothing will happen to this man? Can they do that?
They can't.
That's what I'm trying to say. I cannot also.
This is not going out of proportion.
No.
Hundreds and thousands of
Is
public
a
interest
pub-
litigations are being
protection
so
of
many important issues.
the very object
And
of
the
promulgation of the.
passed regularly by the court taking this.
Yes.
It's not a
Every
question
day.
of that. I am talking about Protection of Whistleblowers Act. The very object of the act is this. Because whistleblowers are suddenly seen accident, run over by trucks, things are happening to whistleblowers. It's not unknown in this all over the world. But this is the very object of.
Reference will be made to the order dated 12th May 2023. On by the said order, we directed the writ petitioner to appear before this court along with this proof, identity proof. Appear before this court in person along with this proof of identity. Mr. Bose, learned advocate appearing for the petitioner has submitted an envelope containing the Aadhaar card and other details of the petitioner and submits that the petitioner apprehends danger to his life if he is identified in open court. The learned advocates appearing for the respondent would submit that the apprehension is absolutely baseless. In any event, this court needs to ascertain as to the very existence of the writ petitioner, which is being doubted by the respondents, and also to verify as to whether he has signed the affidavit filed, signed the writ petition, which has been filed as a public interest litigation. Therefore, let notice be issued to the petitioner to appear before the registrar original side of this court, along with his original proof of identity on any working day before 4 p.m. and also state as to whether he has affirmed the writ petition filed as a public interest litigation. Let this order be communicated by the registry to the petitioner within 2 days from date.
Innovation of Mr. Moinak Bose. Innovation of Mr.
How do I say somebody comes and says this is my apprehension? Can I say it's unfounded?
We'll find out. We'll find out.
And
let the matter appear on 3rd July. This original you can give it to him.
And Mala, would it
If
be
he is standing outside, you can give it.
One more indulgence. Would it be a lordship pleasure to indicate, direct the registrar original side to file a report after this exercise is undertaken?
All right, good. The registrar original side shall file a report in this regard. Next.
Item number 4.
But there is a direction for filing a little note.
I have prepared it. Would it lordship be
Give a copy.
file it today or we?
You can give copies, you file it.
Very.
Plus, sir, add one more sentence. Sit down and take. In terms of the earlier direction, a brief note has been prepared by the learned advocate for the petitioner, which has been filed and taken on record. Copies of the same be furnished to the
We will do that. We'll do that.
learned advocates for the respondents.
We don't have sufficient copies.
Item number 4,
Yes.
We have put the petition.
Exception to the report has been filed.
Yes, exception to report is here, my lord. I am filing it.
And who will appear for the respondents, sir?
The last occasion they were there.
Advocate General was appeared.
Initially, the Advocate General was appearing along with Mr. Somrat Sen. And the last occasion, my lord, who appeared? Tale Masood Siddiqui appeared, my lord, before your lordship. My lord, may I file the, my lord, the
Where is
reply
Mr.
to text?
Siddiqui is not here. Mr. Chatterjee is no longer in the panel.
My lord, Siddiqui
He is there. He is there in the panel. He
He's there in the
continues. Mr.
He's in courtroom number 5 and 10, my lord. He is coming. I double check. He's coming. He's
coming.
coming. Yes.
Passover. No.
As your lordship, please.
Or when we can have Anjam?
We shall wait.
Friday.
My lord, we can wait a bit, my lord, let him come. We can wait a bit, my lord, then let him come. That's is inclined to pass it over.
item number 5,
Your Lordship, I'm praying for adjournment, Mr.
Why you're not ready?
No, Kaushik Dey is appearing for the matter. Advocate Kaushik Dey. He's not well. He did not come to court today.
Oh, he's not well. They say counsel is not well. It is submitted that the learned advocate appearing for the appellant is indisposed. List next week.
Wait for your
Next week.
item number 6 and 7 for admission.
I'm led by Mr. Shomo Mujumdar, my lord. He's on his legs, my lord. Kindly keeps it next week any day, my lord. Convenient to lordship.
I leave it to your lordship.
At the request of the learned advocate for the appellant. Next week. Give a date.
Item number 8,
My lord, your lordship had condoned the delay in this appeal. The subject matter, my lord.
260.
And the unexplained cash credit is the subject matter of this appeal. If your lordship kindly turn to my lord, page 3 and 4 of the stay petition, wherein my lord the substantial portion of law.
Paragraph 6.
My lord. I'm placing that, my lord. Whether the learned tribunal was justified in deleting the addition of ₹20 crore made by the assessment officer on account of share capital and the premium in the course of assessment in absence of identity of the creditors, genuineness and creditworthiness of the entire transaction. Whether the learned tribunal was justified in deleting the addition of ₹20 crore made by the assessment officer where no personal attendance was made by any director of share LLC companies during the course of the assessment proceeding, and as such the identity and creditworthiness of the creditors and genuineness of the transaction could not be verified. Whether the learned tribunal has erred in considering the facts that the assessee company discharged its owners as is envisaged under section 68 of the Act. So my lord, this is my lord the questions of law, my lord, that has been proposed to be framed. Now, my lord, the relevant factual aspect, my lord, that is, my lord, appearing at page 8 of the assessment order, my lord.
Yes.
I'm placing that portion, my lord.
Yes.
It starts from page 7.
Page 7.
Page 7. It starts from page 7 of the, that is the page 7 of the stay petition, where from, my lord, the relevant portion, the assessment order is starting. My lord, I've got it. It was found from the records that the assessee raised capital at a huge share premium during the year. but the assessee failed to justify the high value of such share premium and corroborate creditworthiness of the subscribers of the share at such premium. There was no such business activity or book value EPS which could substantiate the value of the premium of unquoted shares. The replies sent by the investors were almost identical in style and submitted almost at the same point of time. The address of the registered office of some of the investors' companies are same with the common directors. All this proved that the connivance of the associate with the investor company, a summon under section 131 of the IT Act was issued on 9th of February 2015 to the directors of the associate company to examine the basis of premium, and the assessee was also requested to produce the directors of the investor company to examine their identity, genuineness of the transactions, and their creditworthiness for such investment. But the directors of the assessee company failed to appear in compliance of the summon under section 131. The assessee failed to corroborate the creditworthiness of the investors despite reasonable opportunity. Hence, such because of the share applications with huge and unjustified share premium was received from the corporate entities through banking channel does not justify the creditworthiness of the shareholder. It is for the assessee to prove its claim of share capital introductions.
Mr. Mitra, sorry for interruption. The tribunal has just quoted this good point, Como deal.
My lord. And tribunal, my lord, had gone on to, my lord, the reproduce the entire judgment as a whole, but my lord, whether that judgment was, my lord, fit enough for the purpose of this particular case or not, that aspect, if I could humbly submit before lordship, has not been discussed.
The tribunal was of the view that the amount received as share application money cannot be added under section 68, for which it quoted. And what happened to this good point? No appeal was preferred.
No, so far I believe there is nothing, my lord.
But at least some discussion on facts could have been done by
the Commissioner Appeals had done that exercise. But
tribunal should.
Because those were the given facts.
Suppose we do the same thing, will you allow us?
Because actually the Commissioner Appeals has reproduced the assessment orders of all those 6 subscriber companies. And some of them was made under 263.
No, what it can do is, of course, state the law and also examine some examination of facts.
The only thing, my lord, if I could, my lord, put it like this, that the logic, my lord, that was found placed in the assessment order, my lord, that was also, my
And
lord,
he added 94 crores.
No, 20 crores. Not the Commissioner.
24 crores.
So 20 crores.
20 crores.
No, 38 lakhs was added. There were 8 subscribers. 2 of them, assessee could not get the papers, so they were added. The other 6, the Commissioner Appeals has made a list. One of them was assessed by the same assessing officer, and he's reproduced the assessment orders, some of which were passed under section 263. In some cases, 3 cases, the share capital was added in their hands. In 3 cases, it was not added. So that entire factual examination had been done on the basis of departmental records. It had been done. And therefore, the tribunal has said that when those companies have been assessed, therefore, there's no scope for making any addition.
CIT appeals order is a very detailed order.
Yes, if I can just show, if my lords are pleased to see, first page 11, where he says that there's no notice under 131 issued to any of these subscribers, only to one. Page 11, the last paragraph. And there from the assessment record, the Commissioner Appeals mentioned the facts. And then, if my lords are pleased to see, page 44 after that.
It's a 102-page order.
Because he has reproduced the assessment orders in all those 6 cases. Because he also wanted to.
Tribunal could have.
No, the tribunal's logic is those are undisputed facts. The assessment orders in all the 6.
The tribunal doesn't record it. Tribunal just quotes it and says that applying the above ratio.
If I may
come to page 134, applying the proposition of law, they lay down in these case laws of the facts of the case, we uphold the order, dismiss the appeal. some brief discussion.
If I may just kindly see the at page 113, paragraph 5, they say we have heard the submissions. Then in 6, they about that 133, 131. Then the 6.1, they mention about the different companies and the documents. 6.2 about the 133.6. Then 6.3, assessment orders of the following companies have been passed under section 143.3 of the Act for the same assessment year 2012-13. Details are given below. Learned CIT has produced these assessment orders in his order. In the assessments of some of the share applicants, additions have been made under section 68. These are so and so. Assessee has also submitted the source from where they have received funds for making investment in the assessee company. All the transactions are through banking channels and are documented. Learned CIT appeals have deleted the addition made under section 68 of the Act of credits received from 6 companies whose assessments were done under section 68. The section 68 additions of the other 2 companies are confirmed with Learned Commissioner appeals. The facts are
No, I think it is not very clear whether it is contention or thing. But in page 6, I'm sorry, page 116, first paragraph, last 2 lines. The issue before us is whether this deletion on the part of the addition made under 68 by the CITA is in accordance with law. Thereafter, the discussion.
Yes.
Discussion is 6.5. He says it cannot be added on 68. Judgment in good point.
Because those companies have been assessed and therefore
we'll send it back. Let them take it.
I would also, my lord, indicate, my lord, there was a contention that was raised before the tribunal, my lord, indicating certain facts that there is no discussion.
This appeal filed by the Revenue under section 260 capital A of the Income Tax Act 1961, within bracket the Act, is directed against the order dated 23rd June 2021 in ITA number 313/KOL/2020 for the assessment year 2012-13. The Revenue has raised the following substantial questions of law for consideration. Page number 2, 3 and 4 of the stay petition, para 6, 1, 2 and 3. 3 questions. We have heard Mr. Tilak Mitrol and Senior Standing Counsel for the appellant, and Mr. J.P. Ketan, learned Senior Advocate, assisted by Mr. Kutyush Junjunwala, learned Advocate, appearing for the respondent assessee. The question which falls for consideration is whether the addition made by the assessing officer under section 68 was in accordance with law, and whether the Commission of Income Tax Appeals for Kolkata within bracket CITA was justified in allowing the appeal by his order dated 13/12/2019. At the first blush, on perusal of the order passed by the learned tribunal, we thought the order is a well-reasoned order, taking into consideration all the issues and then rendering finding, as the order runs to 25 pages. However, on a closer examination of the order, we find that the discussion of the matter, a discussion of the case begins from paragraph 6.5 of the order, wherein the court, after noting the issue to be decided, has referred to the decision of the coordinate bench of the tribunal in the case of ITO versus Good Point Comodil Private Limited, dated, in ITA number 1204/2015 for the assessment year 2012-13, dated 7/6/2019. We find that the entire order passed in the said decision has been extracted in full, and in the last paragraph, in paragraph 6.7, the learned tribunal states that applying the proposition of law laid down in the case law to the facts of the case, the tribunal is satisfied that the order of the CITA has to be upheld, and accordingly the appeal filed by the Revenue was dismissed. Prime facie, we are of the view that the order is a non-speaking order. Mr. J.P. Ketan and a senior advocate appearing for the respondent assessee submitted that the CITA, while considering the appeal, took note of all the facts and also the assessment orders of the 8 companies, eight companies, six companies, and has extracted some of the assessment orders, and the CITA has given elaborate reasons for allowing the appeal, which order has been confirmed by the tribunal. It may be true that the order passed by the CITA is an elaborate order, as it could be seen that it runs to 102 pages. Nevertheless, the learned tribunal, being the last fact-finding authority in the hierarchy of authorities, it is required that the tribunal is to record reasons for affirming the order passed by the CITA, since facts have to be gone into to justify the findings of the CITA. In the absence of any such finding, and also in the absence of any clear discussion as to how the proposition of law which were referred to in the order passed by the coordinate bench of the tribunal in the case of that, Good Point Commodity Private Limited, is applicable to the facts and circumstances of the case, has to be recorded by the tribunal so as to qualify to be a recent order. Thus, we are satisfied that the matter has to be reheard by the learned tribunal by considering the facts of the case and then coming to a conclusion as to whether the order passed by the CITA is to be affirmed or not. For such purpose, we are inclined to remand the matter back to the tribunal for a fresh decision on merits and in accordance with law, bearing in mind the observations made in the preceding paragraph. Bearing in mind the observations made above. In the light of the above discussion, the appeal is allowed, the order passed by the learned tribunal is set aside, and the matter is remanded to the learned tribunal for a fresh decision on merits and in accordance with law. Consequently, the substantial questions of law are left open.
I'm great. I'm extremely grateful, madam.
Item number 9.
Yes, sir. What is this?
Well, it's in this matter, Lord, I had submitted before the vacation, Lord, that this tax effect is less than.
You got instruction?
Lord, I have tried, Lord, but I did not receive, Lord, but Lord, I find, Lord, there maybe a judicial order from your Lordship, Lord, because.
But if I may just show to my Lordship, some time has passed. If my Lords are pleased to see, Lord, the assessment order, Lord, at page 22.
Yes, sir.
Yeah, Lord, the question was, Lord, regarding the
page 22.
22, Lord, can you see the last table on that page? Lord, the dispute is regarding that ATIC deduction. So Lord, the profit of the ATIC unit is 18 crore 84. The adjustment with the revenue made is 6 crore 57. Then, Lord, then the deduction under section ATIC is only 30% of the amount.
ATIC profit 18, 6 crores adjusted, other income interest so and so. Total is 7 crore 10 lakhs.
And so then Lord, the deduction is at the rate of 30% only. So Lord, they have calculated tax on 6 crore 57 and not, Lord, on the 30% amount. Kindly see the next page now. It will be clear from that. Can you see the next page? Hence, the deduction under section ATIC will be reduced to rupees 2 crore 13 as against the claim of the assessee of 4 crore 10. So Lord, the difference is 1 crore 97 lakhs. So that is the income involved in respect to which the tax has to be seen. So Lord, on the last occasion I had submitted that the tax on this comes to Lord 60 lakhs, 65 lakhs,
65,05,587.
Lordship. And my Lords had look at page 26 on the last occasion, because in the Commissioner Appeals Order, Lord, the figure of tax penalty and interest is mentioned. So this amount, Lord, was more than 1 crore. So my Lords were curious as to what this is made up of. So Lord, I got the computation sheet. I'll give a copy to my learned friend, but kindly have a look at this one. If my lords are pleased to see not the second page of this.
Yes.
And the final details. My lord. The final details, note this 1 crore 3 is the last figure. The breakup is just above that. Note the tax is 80 lakhs 5,462 and the rest 11 lakhs 18 is interest under 244A and 11 lakhs 86 is again interest under 234D. So the tax amount, not even according to this, is less than 1 crore.
Please take note. This appeal filed by the revenue under section 260 capital of the Income Tax Act 1961. Within bracket, the act is directed against the order dated 23/6/2022, passed by the Income Tax Appellate Tribunal, C Bench, Kolkata, within bracket tribunal, in ITA number 264/KOL/2020 and CO number 05/KOL/2021 for the assessment year 2015-16. The revenue has raised the following substantial questions of law for consideration. Page number 5, para 7, page number 5 and 6, A, B, C, D, E. We have heard Mr. Soman Bhattacharjee, learned senior standing counsel for the appellant revenue, and Mr. J.P. Ketan, learned senior advocate, assisted by Mr. A.P. Agarwala, learned advocate for the respondent. On the last hearing date, the learned senior counsel for the respondent assessee submitted that the tax effect in the instant case is less than rupees 1 crore, that is rupees 65,05,587, and therefore the revenue cannot pursue this appeal on the ground of low tax effect. In order to afford an opportunity to the revenue to come back on the said submission, the matter stood adjourned by order dated 12th May 2023. It appears that no specific written instructions have been given to the learned senior standing counsel for the appellant in this regard. Nevertheless, the court examined the matter. As could be seen from the order passed by the Commission of Income Tax Appeals, as could be seen from the assessment order dated 18th January 2019, passed under section 143(3) of the Act, the particulars with regard to profit of the section 80 IC unit has been given as hereunder. Sir, please quote this from page 22. I will mark with red ink. Page 22 and 23, first paragraph. Thus, it is seen, from the above table, it is seen that the deduction under section 80 IC at 30% of the profit is rupees 2, 13, 11, 566.
As against the assessee's claim of 4 crore 10.
As against the claim of the assessee of rupees 4, 10, 25, 466. If this is taken, the tax effect will be less than the threshold limit of rupees 1 crore. However, on perusal of the order passed by the Commission of Income Tax Appeals 22 Kolkata, within bracket CATA, dated 11th February 2019, the tax amount is mentioned as rupees 1, 03, 10, 590. In our view, the said computation is on account of an arithmetical mistake, on account of a mistake computed while computing the while not rightly noting on what amount the tax has to be computed. If we peruse the income tax computation form for the relevant assessment year, under the heading final details, the following have been mentioned. So this is a separate sheet. As could be seen from the above table, The total tax is rupees 8005462. Thus, it is clear that the tax effect in this instant case is less than the threshold limit fixed by the CBDT. Hence, the revenue cannot pursue this appeal. Accordingly, the appeal stands disposed of on the ground of low tax effect, and the substantial questions of law are left open. I'm grateful.
Only my lord, one thing, my lord, your lordship mentioned, my lord, CIT appeal order that is dated 31st October 2019. Your lordship mentioned 11 February 2019.
Oh, that is the date of hearing.
Hearing, sir. 31st October.
31st October 2019.
31st October 20, CITA. Thank you, sir.
Diplo.
Next.
Item number 10.
Yes. Assessee's appeal. Very rarely the assessee is here.
Lordship. Now, here, if I may just give the background. The assessee sought to raise capital, share capital from its holding company. It was in the renewable energy field. Some of these projects are undertaken. The way they structure it is that there's a holding company, there's a subsidiary, there's step down subsidiary. So not each project is undertaken through a subsidiary. It may be several steps down, because then ultimately if the project is successful or it is unsuccessful, transfers are easily possible at that stage. It does not affect the, I'm sorry, it does not affect the corporate, the parent company.
Parent company.
So here the shares were, this was at a stage where projections were made. Any startup, not anything which starts new, projections are made that this is going to be the future earnings and this is going to be the future cash inflow, etc. So based on that, the calculations are made to find out what can be a possible premium, what could be the possible share price. There are rules in place which provide for computation on the discounted free cash flow method, where future earnings are taken into account. So based on that, and that is done by an expert. So based on that, a premium was decided for 10 rupees, every share of equity share of rupees 10, or 2 rupees 50 will be the premium. And this assessee is taking from its own holding company. And for each preference share of 100 rupees, which is going to be compulsorily converted into equity shares, there also the premium should be corresponding 25 rupees. Based on that valuation, the capital was raised. Now, in course of the assessment, these papers were presented. So, the assessing officer was not seriously looking into the matter. So, directions were obtained under section 144A from the additional commissioner. Additional commissioner directed the assessing officer to refer the matter to the department's expert valuer and then make the assessment. So, that instead of making the reference to the appropriate expert, the reference was made to the immovable property valuation cell. So that officer, obviously, he said, I am not equipped to deal with this. He did not make any valuation. Assessing officer added the entire share premium, 8 crores odd. Then the matter traveled before the Commissioner Appeals. The Commissioner Appeals directed the assessee to have another valuation made and directed that this should be sent to the assessing officer, who will consider it and send his remand report with his comments on it.
That is, assessee will do it in an independent private
to another
another agency,
another an expert. So, but his report was obtained, a different person this time, and that was sent to the assessing officer. Assessing officer did not make any adverse comment on that. He forwarded it to the Commissioner of Appeals without making any adverse comment. I show those portions. So the Commissioner of Appeals noted that there is no adverse comment by the assessing officer. Then the commissioner noted that this group, he has mentioned the figure. If I can just read those 4 lines from the order, because that is an important part. If my lords are pleased to see, page 23 is where the order starts. And if I can just take my lords to page 28. Sixth line of para 3.5. Both the share capital has been raised from Mrs. Placid Limited, a group concern of the SSC company. Placid Limited is a group concern of Bangalore Group, a reputed business house of Kolkata, and the company is having a net worth of more than 500 crore. During the course of appellate proceedings, the source for investment Placid Limited was also called for and also found to be properly explained. Therefore, it is obvious that the subscription of preference shares and equity shares has come out from reputed companies from explained sources. So this was it is a genuine business venture undertaken by an established business house. Money was being transferred for funding by the holding company to its subsidiaries. The subsidiaries before my lords. Now the
subsidiary is the SSC.
Yeah, is the SSC. It got this money from the holding company. Placid is the holding company. Now the matter, revenue prefers an appeal before the tribunal. The SSC files cross objections. In the initial cross objection, the point taken was that the appeal is not maintainable because it was based on a remand report, which the on the SSC's AO's remand report where there were no objections to this. That was the first. And then alternatively, additional cross objections were filed saying that the original direction under section 144A that had not been complied with by the assessing officer because he did not send it to the proper person. So these grounds were taken in the cross objection. Now, when the matter is taken up by the tribunal, this argument, that tribunal notes it. I'll show from the order. Tribunal notes my argument that the appeal is not maintainable. There's a decision of the Honorable Madras High Court which is relied upon. But it is also the reference is noted. But ultimately, the tribunal does not deal with that point.
Why appeal is not maintainable?
Because it is based on a remand report to which where the assessing officer had no objection to that. So, if a valuation is made,
so they cannot be said to be agreed.
Agreed. So, at this point, it was the argument is noted, the citation is noted. But
so under 250, they cannot. They cannot prefer an appeal.
Yes, now this was and the other argument that the compliance of the original direction under section 144A had not been made. Even that point is not decided. What the tribunal goes with is this. The tribunal says that your valuation is based on workings of other companies who are, you say, are your step down subsidiaries, but on that date, they had not become your subsidiaries. So they say that, therefore, this cannot enter into the valuation. Remember, the entire thing is a projection. That money is not earned. The entire thing is based on projection. So the structure is being put in place. It is all within the same business house, money being transferred from the holding company to the subsidiary company. The subsidiary will, again in its turn, fund its step down subsidiary. Those companies are all there, but it takes time. So things move simultaneously. It is not that everything is in place and then one loses time. So the tribunal simply, on the basis that those two companies on whose projections the valuation was based, they had not by that date, and tribunal, my lord will find from the order, the tribunal accepts that they had become subsidiaries. But on that date, they say they had not. So therefore, it cannot be taken into account for determining the premium. But in that case, everything else, everything was in the future. All the projections are entirely, it's a new project. So in fact, any startup, when they want to raise funds, it has to be on projections. There has to be some as to the viability of the project, what can be the possible earnings
on what is the amount tax was levied?
On the entire premium.
Share premium.
Yes.
The 12 rupee 50 paise.
Yes, 2 rupees 50 paise for the equity share and
premium. Sorry.
And 25 rupees for the preference. So that 56 subsection 2 clause 7b. One of the arguments is that it cannot apply between a holding company and a subsidiary. So this is the tribunal holds that I did not supply complete information to the valuer. So the valuer has not taken into account the fact that these two companies were not my subsidiaries by that.
Tribunal notes that you had raised an issue regarding maintainability of the.
Yes, that argument is noted. If I may just show that. if my lords are looking at the memorandum of appeal, if I may show from there. But if my lords are pleased to take note, page 3 of the tribunal's order is annexed to the memorandum of appeal.
But the CIT appeals does not record that the assessing officer on remand has not given any adverse comments.
He is recorded.
Page 28.
Yes, if I may show page 20. Kindly take from page 27, paragraph 3.3. This is a letter to the AO. Page 27.
AO has not found any fault in the valuation report submitted by the merchant banker appointed by the assessor.
And then his AO's report is also not set out.
So he agrees how the working has been done.
And then
but essentially the tribunal went behind the correctness of the valuation.
Yes,
but it was entitled to do.
But that going behind, they simply went by that. But everything at that stage.
Now, suppose let us assume we call for a remand report. The assessing officer neither says this nor that. Still, the appellate authority, while allowing the appeal, he should record reasons saying that for such and such reason, though he has not responded to my report, we have examined the report and the report contains all the requisite details, etc. And the valuation is proper and justified. Merely because it is like a civil court granting an ex parte interim injunction without recording reasons. Notice issued, notice served, none appears for the respondent defendant, injunction till. Comply that order 39 to 1 and 2. That is, Supreme Court says, maybe he's appeared or not. If he has made out a prima facie case or he's made out a case, you consider that report and then go into the valuation. So if he has not done that, the tribunal probably was justified in.
The tribunal does not go into the valuation part. They simply say, if I may explain, there was originally a report which was produced before the assessing officer. But the direction was under section 144A to refer to an expert.
He didn't do it.
But then the commissioner appeal gave another chance. But commissioner appeal and the officer has responded.
Yes, he has responded.
And the commissioner appeal went to the extent of going into source of source also. They said he wanted to see whether this is genuine or is it make believe. But he found that this is an established group undertaking a business venture. Now, the reports are also before my lord. The reports are all based on projected earnings. So the structure is falling into place. The funds are being put in place, and then only the implementation will happen. So the tribunal says that we are not, and they say we don't go into the technicals of the valuation. It is not that they simply say that these companies were not your subsidiaries on that date. But if we're going by that basis, that the method itself, the discounted free cash free method, that method is prescribed by the rules. So one has to take into account future earnings. Not everything is in the future. So what has happened is not that the
So in fact, the tribunal has scrapped that valuation report.
Yes, my lord, and paragraph 12, my lords, please.
It says that because these companies were acquired as to become subsidiaries sometime in December.
Yeah.
And the valuation of the share was in November.
Yes. So my lord, they
But
actually,
at least you could have if according to the tribunal, the methodology adopted was wrong. Assessee could have sought for one more opportunity.
this finds place in the order, my lord.
Judgment reserved and then.
Yes, my lord. And my lord, in fact, my lord, kindly see at page.
But Mr. Rai, if
Lord, may I-
suppose the valuation report is doubted, I mean the methodology, not the conclusion or otherwise, should he not get an opportunity?
Lord,
He
should
didn't
not-
have
he
an
has-
opportunity to explain.
Lord, in fact, the SSC has approached, Lord, the Honorable Tribunal, Lord. There is a miscellaneous application which is pending.
That they will dismiss.
That is pending, my lord. That's pending, my lord. And in view of Honda CL, my lord, the tribunal, my lord, is now empowered to look into it, my lord.
It can, it
Lord,
can.
My lord,
It can.
if I may
Therefore,
explain.
Lord, the application.
But I was intending to point out, the miscellaneous application is with regard to the cross objections, because not the tribunal has not dealt with the question of maintainability of the appeal, which I had.
Oh, this, you could have made a prayer to the tribunal. One, explaining to the tribunal that this is of no relevance. Valuation of shares and on what date the company became a wholly owned subsidiary is of no relevance, because according to you, this is only a projection.
Yes, but everything is a projection. Everything.
So therefore, sir, it is difficult for us also to understand the concept, because we are not chartered accountants, we are not cost accountants or experts. So at least at that point, the tribunal, you could have asked of course, they will say if you file an application, it tantamounts to review.
So, although that miscellaneous application is pending, my humble submission is not if the matter could go back. And not they can also deal with those grounds and not also deal with this, because paragraph 12 at page 9.
What we can say is, we can say that the tribunal in paragraph 14 has come to the conclusion that the valuation done was wrong. The methodology adopted was wrong, or the valuation was wrong, for the reason that those two subsidiary companies were acquired much after the date of valuation. Your reasoning is that that is of no significance because the figures are all projected figures. In any event, if so one more thing is, your argument is he did not draw any adverse comments on your report.
Yes.
Commissioner gave an opportunity. That report went back to the assessing officer. From what it is quoted on page number 28, it appears that the AO agreed with the evaluation. If that is so, whether an appeal was maintained is the other issue. If that is so, the tribunal, whether it was justified to go into the correctness of the report, but not the arithmetics, the methodology.
Well, kindly see paragraph 12 once.
Because they also lack the expertise.
Well, that's why those two reports were there.
The valuation officer lacked expertise.
In fact,
The bench lacks expertise. This bench lacks expertise. Everything, only councils have the expertise.
Startups, they raise funds.
Yes.
Not based on projections entirely.
In fact, that is accepted norm. No?
Yes,
inflate the value of the assets. Why giving reasons so as to avail higher overdraft facility? That is accepted norms. And based on that presumptive value, you don't tax the assessee.
Yes.
That several decisions.
Yes. So this is entirely, it's just new business being started. Therefore, there have to be projections. And kindly similar paragraph 12 of the tribunal's order. So page 19, running page 19 of the tribunal's order, paragraph 12. They say we are not refrain from making any comments on the technical
Correct,
aspects.
I saw that.
So therefore, they are not. They are simply going by this, an insignificant aspect. I mean, they do not even.
And you didn't have an opportunity to counter it.
I'm not in the miscellaneous application. I'm only.
What is the prayer in that MA?
No, it is here with
Page
my
255.
255.
Volume 2.
Right. So just point out the MA is only in respect of the my cross objection, not page 261.
261.
58 are the grounds.
261, paragraph 26. And no, just above that, in fact, prayer. Accordingly, it is at page 261.
Accordingly, is not met. This they won't accept.
No, therefore, I was praying that
unless it goes back, they won't
it
accept.
needs to go back. So the entire thing is addressed.
But prime facie, still it is open to the tribunal to,
yes,
of course, to consider.
Yes,
but in para 12, they say they refrain from giving. They should not have said that.
Yes.
They could have probably even called a second remand report.
Yes, they could.
On that, because it is highly skilled.
And this not between holding and subsidiary, 100% holding company, but providing funds to subsidiary to start a new venture. They're not their own funds getting taxed. It's actually for a business.
Step down subsidiary concept itself is for some other purpose. 80% laundering.
Not here.
Not this is a
this is
big,
genuine.
No, I'm saying.
Yes.
And the step down will be obviously elsewhere. Subsidiary and direct subsidiary, step down subsidiary will be elsewhere. So we will send it back. And once we send it back, the prayer in MA also can be considered on merits.
Yes, but if the whole thing goes back,
all issues can be considered. This appeal by the SSC, filed under section 260 capital A of the Income Tax Act 1961, is directed against the order dated 30th November 2022, passed by the Income Tax Appellate Tribunal A Bench Kolkata, within bracket tribunal in ITA number 211/KOL/2018 and CO number 117/KOL/2018 for the assessment year 2013-14. The assessee has raised the following substantial questions of law for consideration. Page number 5 of the stay of the memorandum. There are 3. There are A, B, C, D, E. Page 5 and 6. We have heard Mr. J.P. Ketan and senior counsel for the appellant and assisted by Mr. Pratyush Junjunwala. Bagaria is also there, and Mr. Anurag Bagaria, learned advocates for the appellant, and Mr. Om Narayan Rai, learned senior standing counsel, along with Mr. Soman Bhattacharjee, learned senior standing counsel for the appellant revenue. The tribunal, by the impugned order, had allowed the appeal filed by the revenue, challenging the order passed by the Commission of Income Tax Appeals for Kolkata within bracket CITA, dated 13/6/2018, arising out of an assessment order framed under section 143 within bracket 3 of the Act, dated 30th March 2016. At the first blush, it appears that the facts are very complicated, but on a closer examination, more particularly with regard to the grounds raised by the SSC, the matter is at the threshold projected by the SSC on certain technical grounds. The brief facts which are required for considering the correctness of the grounds canvassed by the appellant are there. That the assessing officer was required to obtain the fair market value of the preference shares. And which was required to be referred to the appropriate valuation officer. The procedure was to a direction was issued by the Additional Commission of Income Tax Range 2 Kolkata on 22/3/2016 under section 144 capital A of the Act. directing the assessing officer to refer the matter to the valuation officer under section 142 capital A of the Act to estimate the valuation, including fair market value of the asset being equity shares of the company, and obtain a report from the valuation officer, full stop. The valuation officer was requested to provide in his valuation report the fair market value of the preference share in terms of Rule 11, capital U, capital A, within bracket numerical 1, within bracket small c, within bracket small c, 2 small c of the income tax rules. The assessing officer, instead of referring the same in terms of the directions issued under section 144 capital A of the Act, referred the matter to the valuation officer who deals with valuations of immovable properties. The said authority had promptly returned the papers on the ground that he does not have jurisdiction to deal with the subject, as it is an expert, as it requires certain expertise. Agreed by the assessment order, the assessee was on appeal before the CIT. The CITA had issued a direction to the assessee to prepare an expert report and a report to be submitted, which was to be in turn examined by the assessing officer for comments. The report was accordingly drawn by an expert, submitted to the CITA, which was referred to the assessing officer for his comments / report. The assessing officer did not find any fault in the valuation report submitted by the merchant banker / accountant appointed by the assessee. Accordingly, the appeal filed by the assessee was allowed. Aggrieved by such order, the revenue preferred appeal before the tribunal. The assessee filed cross-objection contending that the revenue contending that the appeal was not maintainable. As the revenue cannot be stated to be an aggrieved person over the order passed by the CITA, since the assessing officer did not record any objections or reservations to the valuation report submitted by the expert appointed by the assessee. The revenue was on appeal as against the order passed by revenue, argued the appeal argued their appeal on the merits of the matter, seeking to sustain the order passed by the assessing officer. The learned tribunal, after considering the submissions on either side, in paragraph 12 of the impugned order, has held that as far as the preparation of valuation report and its technical aspects are concerned, the tribunal refrains from making any comments. However, the assessee was, the revenue succeeded in the appeal in the light of the reasoning given by the tribunal in paragraph 14 of the order, which is quoted here and below. So, the memorandum of grounds in the certified copy, it is in page number 20. the but this regarding this projection, that ground has not been raised.
But that entire valuation is not, it's
But
entirely
in the,
projection.
in the substantial question, it won't be there. In the grounds, it will be there.
Yes, ma'am. Not the,
Which ground you have said? Yes, ground D.
yes, ma'am.
The submission of the learned senior advocate appearing for the appellant assessee is that the tribunal ought to have considered that for funding each project, financial projections had to be made on the basis of future expected cash flow. And the business sought to be undertaken had to be valued, and such exercise was invariably undertaken well in advance. Further, it was contended that the tribunal should have considered that the dates on which the entities involved in the project became the assessee's wholly owned subsidiaries or step-down subsidiaries was of no consequence. Further, the tribunal failed to consider that one of the methods prescribed under Rule 11, capital U, capital A of the 1962 rules was the discounted free cash flow method within inverted commas. For determining the value of the business of a company and its shares, and the experts had followed the said method in their reports dated 30th November 2012 and 14th March 2018 for the purpose of valuing the assessee's future business and its shares. Several other grounds have also been raised by the assessee. So far as the cross objection is concerned, the tribunal has not considered the specific objection of the assessee that the revenue could not have been said to be an aggrieved person over the order passed by the CITA, since the assessing officer did not record any adverse comments on the valuation report, which was forwarded by the CITA for his comments and observations. However, the learned tribunal held that the cross objection merely supports the finding of the learned CITA. We are informed that the assessee has filed a miscellaneous application before the learned tribunal in MA number
page 255, MA number 10/:2023.
Where do you get it, sir?
But the rubber stamp note at page 255 on the bottom on the right hand side.
MA number 10/KOL/2023, with a prayer that with the submission that the appeal filed by the revenue before the learned tribunal is not maintainable on the ground that the assessing officer has accepted the valuation report without any adverse finding in the remand report and is liable to be quashed. This said miscellaneous application is now pending before the tribunal. From the above discussion and noting the facts, we find that once the tribunal holds that they do not wish to they do not wish to make any comments on the technical aspects, and simultaneously faults the valuation report, two courses were opened to the tribunal. One course which could have been adopted was to afford an opportunity to the assessee to explain as to the date on which the subsidiary companies were acquired, and is it of any significance, the valuation of the share which took place admittedly prior to the acquisition on 16/11/2012. The second option, second option was to call for a fresh valuation report from an expert and examine such a report on facts, as the tribunal, being the last fact-finding authority, was entitled to do so. We find either of the two options were not exercised by the tribunal. Thus, considering the totality of circumstances, we are of the view that the assessee should have been afforded an opportunity to explain as to what would be the significance or relevance of the date on which the subsidiary companies were acquired by the assessee company. No, on the date on which the subsidiary companies, namely the assessees, were acquired by no, because the subsidiaries.
These are step down subsidiaries of mine, Lord. So
Okay, subsidiary companies were acquired by the assessee. And if in the opinion of the learned tribunal, a fresh valuation report should be called for from the expert, that procedure can also be resorted to. That apart, since the assessee has already filed a miscellaneous application to consider as to whether the appeal filed with the revenue was maintainable before the tribunal, that issue also needs to be gone into, as the cross objection has not been filed merely to support the findings of the CITA. Thus, for all the above reasons, we are of the clear view that the matter has to be reheard and redecided by the tribunal on all issues that may be canvassed both by the assessee and the revenue. In the result, the appeal filed by the assessee is allowed, the order impugned is set aside, and the matter is remanded to the tribunal for fresh consideration on merits and in accordance with law. Consequently, the substantial questions of law are left open.
But that MA, technically there are two MAs, 10 and 14, Lord, because there's a separate one in the cross objection.
Number 10, I've said 10 and 14.
Lord, I'm reading.
We'll stop with this. There is one meeting. Any urgent matter? One matter is passed over. So I've got a BC meeting and starts at 4 o'clock. So first, let it remain in the list. Mr. Ganguly is here for what matter?
My Lord. Item number 19.
19, sir.
Yes. Subject to your lordship's pleasure.
Intervention, I'm seeking your lordship's indulgence, blood.
Item number.
Indulgence, if your lordship kindly allows me, blood.
Wait. So let it remain in the list subject to your convenience.
Will it be taken up tomorrow? I can join on virtual.
Virtually you can join.
Tomorrow, Lord?
Item 4 will be taken up Wednesday morning. Also, I understand taking up
Wednesday morning. It will remain in the list. Your inter-C seniority will not be affected. That much we can guarantee. Only thing supposed to be mentioned, withdrawal, something will come on top. 2-3 matters. Because no human interference. CIS is there, no human interference.
I will bless you.
If my matter also
that the exception filed before.
Okay, exception take. Okay.
Item number 19 also remains on board tomorrow.
Yes, let it remain on board, then we will see what can.
Very respectful.
Extremely sorry.
I'm saying that item, the next matter, item number 11. But if that may be adjourned for a period of 2 weeks, it has various issues.
Where is Amit?
I've informed him, your lordship. I've informed him.
Whether Mr. Kundalia is appearing in the matter.
I've informed them.
All right, whenever you want. At the request of the learned advocate for the respondent. Whenever Junjunwala wants it, yes, sir.
I'm grateful.
I'm extremely sorry, blood.
No urgency.
Urgency is blood. One of the prayer is blood to enable them, the person who want to file nomination, but due to obstruction, your lordship's order was there to ensure filing nomination.
Tomorrow the appeal is coming up. Please wait.
Only thing, day after tomorrow, when I can list the matter. Day after tomorrow. Leave was granted.
tomorrow.
Leave was granted,